Recording in progress.
The Chief Justice. And it's the same process. And therefore, you are incorrect, sir, by suggesting that by not being vetted by an institution that had gone rogue at that particular time, and it was known, it was in the public domain that this institution had gone rogue. And that institution, I had been told by journalists just after this last interview on the Gupta lending matter, that it was the institution responsible for the first spy story.
Yeah, okay. Okay, all right. I'm going to argue, maybe let me make it quick here. I'm going to argue that it's inappropriate for the head of an institution to impose a policy that says people at a particular level must have clearance. In other words, if you had these objections, then you should have the objections in principle rather than imposing it on other people, but not on yourself. That's the first issue I'm going to argue. I've heard your response to that. That's fine. But I just want to move to the issue that you touched on, which I had not touched on. So basically, both you and the Deputy Public Protector were not security cleared.
As had been the institution since its inception.
I take that as a yes.
It is a yes.
Good. And in the case of the Deputy Public Protector, I think he spoke about this openly in the Portfolio Committee. One of the issues why did he attempt to get security cleared?
Not during my time, because it was not a requirement. The Deputy Public Protector was not the first Deputy Public Protector. Advocate Shai was the first Deputy Public Protector. For 2 terms, nobody tried to vet her.
Yes.
And there were 2 public protectors before me. For 2 terms, nobody tried to vet them. But there was an equivalent parliamentary process that I regarded as equivalent to vetting. And that's the open one where anybody can, during the process, bring in issues.
Ma'am, it's going to help us a lot if you just answer the question. So at that particular time, for all the good reasons you've mentioned, both you and the Deputy Public Protector were not security cleared, yes, no?
I've answered that question. I don't know what kind of answer do you want anymore, because
I want a straight answer.
And then I give you additional information.
Yeah. Okay, let me just, if I can come in here, Professor Madonsela, you did answer the question. Perhaps you need to, I think he's asking for shorter answers. That's
I would say, through you, Chair, my answer would be, we were vetted in a different way, in that we went through the kind of vetting that you see in the United States, where MPs like yourselves are allowed to get as many people from the public to submit to you anything that they know about this person that they think makes them not a fit and proper person. So my view is that we were vetted, maybe not security cleared by the State Security Agency. And if I were to make that decision, not to allow myself to be vetted by them at that particular point, I would still make it.
All right. And okay. So, okay, fine. We'll take that as a yes again. Yeah. And I wanted to say that in the case of Mr. Malunga, and I think this is something he spoke about openly, one of the issues that was raised for, or rather that might have stalled his security clearance, was the fact that he came from Zimbabwe. You remember that?
I don't appoint deputy public protectors. I didn't know that because I had never asked him. I had never tried to get him vetted because that was a parliamentary process.
Yes, okay. But you knew that he came from Zimbabwe?
No. I knew that he lived in Zimbabwe, he had lived in Swaziland. I didn't know where he came from. I never asked him.
Oh, come on, Advocate Madonsela. This is something that was being discussed in the public domain, but that's fine. That's your answer. That's your answer.
That's
and
my answer. I never asked
yeah,
him.
Yeah, no, I know it's your answer. I just find it incredulous. Yeah, but anyway, that's fine. Mr. Malunga was called as a witness, but it was decided that he shouldn't come. So I don't think it would be unfair to discuss him in his absence. But you yourself, you were born in South Africa?
I was, certainly. You know that information, don't you?
No, I wasn't there when you were born, ma'am. I'm just...
I think it's in the public domain. Like you say, I should have known about Malunga. You should have known about me too.
Okay, so then you agree with me that you should have known about Malunga now?
Well, I'm saying by your logic, I don't agree with you. I'm just saying by your logic, then you should have known about me. It's not my logic, it's your logic.
I see. No, that's fine, ma'am. The public is listening. No, I was simply distinguishing. I was saying that in your case, rather, in his case, there was that issue, but that issue did not arise in your case. And so I'm just wondering, okay, let me ask this question so that we move on to the next topic. When, for example, as you correctly say, this was raised with you when you were investigating the so-called Gupta landing at Waterkloof, don't you think that that particular issue, obviously the landing of a foreign plane in Waterkloof, which is a military airport, would be a matter dealt with by the SANDF and, among others, military intelligence? Don't you think that your lack of clearance of cleared status would limit you in investigating something like that, because it might involve documents to which somebody like you would not have access? And just, if you don't think so, just say so. Don't tell me why. If you do think so, just tell me.
I don't think so, in the same way that it doesn't limit judges. But you are correct. You are incorrect. Again, you've distorted what I said. I said, as I was, can I just correct you?
No, but you can't insult me at will like that. Chairperson, can you ask the witness to stop saying that I've distorted anything? She's been insulting me.
But you've done that, sir. Can I correct you?
Okay, go ahead.
Thank you, sir. It's on the record. Everything that we're saying is on the record, and there are people listening. I did not say that they asked to vet me for the Gupta landing. I said, as I was concluding that, the last witness that I interviewed was from the State Security Agency, and they knew where this whole investigation was going, because we had done a forensic and we caught them lying. And shortly after that, two things happened. One was the spy story. The second thing was a letter requesting to vet me. The issue of me being not vetted and not having an objection to me accessing information was not in this case. It was with the Nkandla case. We discussed it and we agreed with the ministers concerned, a whole cluster of ministers that had been appointed by President Zuma to deal with me in this matter. We agreed that the public protector goes through public scrutiny that is similar to vetting, and therefore it was improper to refuse to give me the documents from Nkandla. So that was a totally different thing, and it was agreed to. And then out of the blue, the State Security Agency
all
now
right.
wanted to vert me.
Thank you.
Not
You
in
can pause
relation
there.
to any case, just out of the blue. And they said it would be
Okay.
good for me to do that in writing.
Your point is well covered, Advocate Mpofu. Advocate Madonsela.
Okay.
Over to you, Advocate Mpofu.
Thank you. All right. Now I'm going to start protecting myself because the chair is refusing to do so. Let me just tell you for now that your accusation that I was distorting information is unfounded. I have no reason to distort anything, madam. I'm just asking you questions. It is you who said in your statement that you resisted being spied on by the State Security Agency through sudden repeated requests to vet me as I was finalizing the Waterkloof landing incidents by the Gupta family. I'm simply asking, based on that statement of yours, which I've now quoted verbatim so that you don't accuse me of distorting information, which would be highly unprofessional. But the issue I'm saying is that, don't you think, and you may agree or not agree, that for an investigation such as that one, it might be a limitation not to have access to certain documents when by its nature that investigation involves classified information?
It was being finalized, sir. So all of the investigation and access to documents had already been done. As my statement says, it wasn't before I did the investigation this was raised. It was when I interviewed the last person who was a member of the State Security Agency. A few days after that, when I'm talking finalizing an investigation, I'm talking writing the report, which for whatever strange reason never saw the light of day.
Yes, okay. Let's quickly go to the bundle C, folder 2, item 27, please, Tsepa.
Are you winning, Slow Tsepa? Okay.
Right, thank you, Chair. If we go to the first page. Okay, 1.1, it says here, the Public Protector South Africa depends on its personnel information and assets to deliver services that ensure the health, safety, security, and economic well-being of South African citizens. It must therefore manage these resources with due diligence and take measures to protect them. You remember that?
No, I wouldn't remember it. It happened so many years ago and we live in the digital age. But
okay,
I take it that it's from my institution, my former institution.
Okay, ma'am. Let's assume you don't remember it, but you can't dispute that it was part of the policy.
I cannot dispute that. I cannot see my signature on it because the policies that were signed by the Public Protector would have my signature on it. I have no reason to say yes or no.
Fine, let's go to page 459.
If you show my signature, then I will say yes.
Let's go to page 459. Further down. Is that your signature?
Yes, it's my signature, but it's not initialed every page. So I don't know if it's changed, but I want to believe it because it is an old statement that it must have been.
Yes, no, I agree with you. Yeah, in fact, the facility of initialing every page is meant to stop fraudulent activities. You are right to make that qualification. Am I right?
I know where you're getting, Advocate.
I don't know about where I'm getting. Just
Advocate
answer the question.
Mpofu.
Just answer the question.
I don't know.
Oh, so why did you tell the chair that because it's not initialed every page, it might not be authentic? If you don't know now, when the implications of that question are made
It's
clear
not about fraud, it's about you were attributing it to me, and I was saying, I don't know. And I said, if it's got my signature, then it must be me. But since it's not initialed, I don't know if it's been changed because policies are changed over time. But let's just accept that this is a policy that I signed, and it's a policy where I was required by the Auditor General to sign, and I complied. Okay, that's fine. And as it happens, also what you've just said is not true. You did initial every page because you knew that that is the correct procedure. Well, I didn't say I didn't say I didn't initial. I just said if it's signed by me or initialed by me, that's okay, because you're showing me these things. I don't even know what's the procedure here. Normally, just common decency is such that if you're going to put things to people, you send to them in advance. I mean, you were not prepared to put your client through an immediate process, having been given a document 4 days ahead. And you're throwing documents to me without having shown them to me in advance.
Okay.
So supply the same rules you want for your clients to me, sir.
Okay, thanks, Advocate Madonsela. Just a pause there, Advocate Mayosi.
Chair, this particular policy is initialed on every page.
Is initialed.
On every page.
That's what, yeah.
Okay.
But that's what I just said. I don't know why Advocate Mayosi is jumping in as to use Advocate Bauer's expressions. I've just said to the witness that as it happens that this is signed every page. So
initialed every page.
Initialed every page. So
okay.
What's the purpose of that intervention, Chair?
Okay, that's fine. Maybe she didn't pick that up. Let's proceed.
How do you know
over
that?
To you.
How do you know that she didn't pick it up?
She's saying now.
Oh, okay. That's fine. Ma'am, please, I don't want to debate with you. The record will show that you said it's not initialed on every page. So there's no point in me debating that with you. All I'm saying is the significance of that. You raised the point, not me. Okay? I did not raise the issue about signing every page after lunch. You raised it.
May I just respond?
No, wait, let me finish, please, Chairperson.
Yes, finish, Advocate Mpofu.
Madam, I'm saying that you raised the issue, and I'm simply saying that the only reason you raise it of your own volition as part of either an attempt to disown this document or discredit the fact that it has your signature at the end is because indeed the practice of initialing every page, which you did here, ensures that the signature at the end is not just inserted, because all sorts of things could happen. And I know earlier you denied falsely that in the many affidavits that you signed over the years at the public protector, you and the Commissioner of Oaths signed every page. But let's put that aside. I'm saying you're raising it in this context here. And the fact that you did do the right thing of initialing every page means that you know, despite your fake or feigned ignorance, that that is a guarantee, the signing every page. It's a guarantee.
And I respond to that, sir, because that's an attack.
You don't want me to finish? It's fine. If you don't want me to finish, you can.
Yes. I just want to respond to the digression.
Before I speak, before I finish.
Yes, please, sir.
Don't you, isn't it better to respond once I've finished?
Because you're going to go to a different issue. I want to respond to the lie you've just made.
No, ma'am, I will never go to another issue without giving you an opportunity to respond. Believe me.
Okay.
That has never happened.
Okay.
All right. So I'm saying, madam, that the reason why you, not me, raised that issue is because you know very well, despite your earlier false denials, that the issue of signing every page is intended as a bulwark against forgery or fraudulent documents or people claiming that this is your document. This one in particular, I think, has 54 pages, simply because your signature is on page 58. You know that. You can now respond. Thank you, ma'am.
Thank you, sir. Here is the distortion again advocated for. Earlier on, when we had a conversation, it was about commissioners of oath. You're not telling the truth, sir, when you say, I said, I never signed every page. You asked me, in the practice of commissioners of oaths, and I've been public protector for many years, do I know of any occasion of where there was no joint signatures? And then I said, I don't know, because I don't have a recollection of every document. And this is on the record. I will ask that the committee, when this is debated, we get the verbatim. Secondly, on the issue that you're accusing me of, on the one issue, it was commissioners of oath, and currently we're dealing with a policy. These are two different things. It's signed by one person, and all I asked was if it is signed on every page. To now distort my words and say, I said it's not signed on every page. It's a 59-page document that you've just put in front of me right now. Am I a clairvoyant to have known that it's not signed on some pages? But lastly, on that issue that you've argued here about the fact that if something is not initialed on all pages, it is therefore unlawful or illegal, or it's not an affidavit. You cited something from 1963. I will cite to you something that happened here in this province, which becomes precedent. That is the case of Minister of Safety and Security versus Mustafa Mohammed. It's an April 2010 case that contradicts what you just told this committee, say.
Chairperson, please. Advocate or Ms. Madonsela. Well, she didn't. I asked her, are you registered with the Legal Practice Council? Because there's a member who's, pardon?
It's immaterial.
No, but no, there's a member here, Honorable Malham, who's
just stop trying to bully me, advocating Profi. Stick to the rules here.
No, I just want to know, ma'am, please, this is important. So, a member says that you are an advocate. So I want to know if you are registered as such with the Legal Practice Council. That's all. It's a simple yes or no.
It's immaterial.
So I'll take that as a no.
Take it whatever way you want, say.
Yeah, thank you very much. Yeah, no, I'll take it. Yeah, anyone who's registered with the Legal Practice Council would not struggle with that question, but that's fine. Then it means then I was doing that for the sake of knowing where to report these transgressions. at least with the Commissioner of Oaths, I'm sure he's registered with the Legal Practice Council. So we'll refer him there, and other people involved will be referred to the police. That's fine. All right. No, I was saying, ma'am, I don't want to quibble with you. You would agree, though, that the principle doesn't matter whether in the one case we're talking about an affidavit, in another one we're talking about a policy, in another one we're talking about whatever. The principle of signing or initialing every page is the same, which is to ensure that that document has been properly signed by the person whose signature appears at the end. The principle. Did I agree?
Such as a
Subject to the Zeman judgment of 2010, sir. Thank you.
Thank you, Honorable Malema.
Chair, the advocate, when he asks the question and the witness is not answering or deliberately refusing to answer, I thought it is your role to come in and check if she will not answer the question. Because that thing of her belonging to any professional body is very important and can't be left hanging like that for simple reasons that the advocate had mentioned.
Thank you, Advocate. Honorable Malema. I was satisfied with the answer she gave. It's how she feels to answer that question by saying, in relation to the motion that we're dealing with here, for her it is immaterial. Over to you, Advocate Prof.
You're saying you're satisfied with that?
Over to you.
Your satisfaction is very easy to achieve, Chairperson. This is, anyway, it's fine. We're going to be patient. So
Okay.
Anyway, the public knows, I mean, it's very clear now. We had a public protector who's not security cleared, who's not an advocate, as at least as defined in the current law. And what are you a professor of?
Advocate Mbafu, I'm a professor of law.
Which law?
I am a professor of, I'm appointed as a chair in social justice, as the affidavit says.
Oh, yes.
And the affidavit did not claim that I am an advocate. But again, there's a role of advocates in this country. If you want to know whether I am registered as an advocate, you just need to find that out. But I find your conduct unethical, that you keep trying to threaten me with reporting me. Let's just deal with this case and stop these threats. Let's just deal with this case. Let me answer the questions and let's finish this business and stop with these subtle threats. You're not bullying me.
Okay, ma'am. No,
Chair.
Honorable Malema, I see your hand again.
No, but when you say you are satisfied with the answer, and then if I'm not satisfied with the answer, what happens? Because if these people are answerable to you and you are satisfied with the answer, why are you not taking them to a dining room? Because we are here also, we are not satisfied with the answer. So what happens when we're not satisfied with the answer? That everything satisfies you, then automatically it means we are satisfied ourselves. That question is very relevant for us who are going to be making follow-ups on this question. So please, you can't say you are satisfied and then we must move on. What happened to some of us who are members of this committee who are not satisfied? And we must be satisfied through you. That, Chair, please, can we get an answer for that question? Then you say you are satisfied, as if we are here to satisfy you.
Chairperson, my answer remains.
No. I've not recognized you, Advocate Madonsela. I've not recognized you. Honorable Malemba, please conclude.
Yes.
Yeah. Chair, maybe
Honorable Malema, please conclude.
it looks like there was interference, Chair. Maybe he'll come back once he has reconnected.
Okay, he's frozen.
Thank
That's okay. Advocate Mpofu.
Thank you, Chair.
Sorry, Advocate Mpofu. Honorable Maneli.
No, thanks, Chair. I just want to, for purposes of clarity, so that we understand if we understood it the same. And this is because interjections before, when you tried to come in between witnesses and what is raised by the legal team, have been that you should be satisfied that the witness has responded. It's not about you being satisfied as a person with that response. So I'm just saying you need clarity on that because it will come back again. I don't think it's about you being satisfied because you're not asking the question. The question is asked elsewhere and there is a response to the question. You may not be happy with the answer, but the question is whether there's been an answer to that question. And if that answer is not there, surely the reasons follow-ups have been made is to try and establish the answer to such a question. So I'm just saying, Chair, so that it helps us to also make progress. Thank you, Chair.
No, thank you, Honorable Maneli. There has been an answer, not once. Honorable Sukas.
Yeah, Chair, I also just want to add, Chair, the witnesses cannot become the subject of this inquiry. And we cannot subject witnesses continuously to intimidation. And earlier, there were insults hurled at the witness currently on the currently providing evidence. We cannot do that. It goes against the directives that this committee has accepted. Thank you, Chair.
Well, thank you, Honorable Sukas. Honorable Malema, are you back?
Yes, I got cut when I was still pursuing my question. And then Ms. Madonsela spoke and I was not talking to her. You see, she must not say that she can't be bullied by people and think she can bully us. I was talking to you and I was going to expect an answer from you. She just abruptly interrupted me and say, my answer remains, and then that's when I got cut. I was not talking to her. I was talking to you and I was saying to you, how do we proceed in that regard? Please, no one is bullying her here and she's not going to bully us. You see, staying at Stellenbosch does not give anyone any right to bully us. It's not going to happen that one. Never. It will never happen with some of us.
Thank you, Chair.
No. Are you done, Honorable Malema?
Yes.
Thank you. Thank you, Honorable Malema. You got cut and frozen. Members are still going to have an opportunity to interact themselves directly with the witness. For now, it is an interaction between the witness and the legal team of the public protector. So we're still going to allow that, but I repeat, and I've been directed properly that I'm satisfied with the manner the witness has responded, not once on the issue. It might not be an issue that from the one who's listening that it's not satisfying in terms of what has been asked, but she has tried to respond to the matter.
Yes.
Advocate Mpofu.
Yes, thank you, Chair. No, she has tried, but she has not succeeded. I'm saying, Chair, just to assist Honorable Maneli, your role as chairperson is not simply to be satisfied, and I think I've said this before, to be satisfied that somebody has moved their lips and they're speaking. So if I, for example, I say, are you an advocate? And the person tells me the score of the Kaizer Chiefs game yesterday, that you might be satisfied that they've responded because they have, but you should be satisfied as to whether they answered the question. That's really your role. Because to be satisfied that someone has responded means that people can just come here and do anything.
You know, which is not the case.
Yes,
on
but,
this. That's
but
an,
yeah. So
genuine
and
example.
that's why I wanted to understand. No, Chair. In
Thank
fact,
you.
you're quite right. So I wanted to understand that you are satisfied that she is refusing to answer that question, which is crucial. You know, the very first question, very first question I asked this witness this morning was whether I should refer to her as professor or advocate. And she said, I can use both. And I'm simply wanting now, given the demonstrable lack of knowledge of the law and the regulations, to establish whether indeed, particularly the issues that have to do with affidavits. And I was really asking that, Chair, not to embarrass the witness, but simply, as I said, to know whether any allegations against her should be referred to the Legal Practice Council. There would be no point in doing that if she's not registered with that body. But it's fine, Chair. The public, I think, will make its own conclusions. I don't want to waste time on this. So, Ms. Madonsela, the policy that you signed says, can you go to, I think it's 40. So yeah, 40 in the policy itself now, which you initialed every page, thanks. It's 4.3.5.1.1. Yeah. You people at the Public Protector know how to number documents. 409. 4.3.5.1.1. Okay, so it tries to cover it says all employees, contractors, and consultants of PPSA who require access to classified information and critical assets in order to perform his or her duties must be subjected to a security vetting investigation conducted by the state security agency in order to be granted security clearance at the appropriate level. The level of security clearance is given to a person will be determined by the content or access to classified information entailed by the post already occupied or to be occupied in accordance to their respective responsibilities and accountability. Then a security clearance provide access to classified information subject to the need to know principle. I'm just paraphrasing. The essence of that is that people who are going to have access to sensitive information must be subjected to security vetting investigation. Is that a fair summary?
No, it doesn't say people, it says staff. It says personnel.
No, I didn't see that, but it says.
It doesn't say people, sir.
Yeah, it doesn't say staff either. It says employees, contractors, and consultants, and those are people, human beings, you understand? So I'm saying those employees, contractors, and consultants, those people who require access to classified information must be subjected to security vetting. Is that a fair summary of what the policy that you signed requires?
It speaks for itself, say yes.
Yes, thank you. All right. And now, all right, we've already established that you signed this because its absence was seen as a deficiency by the Auditor General, correct?
Yes, sir.
Good. Right. Okay. Then I think, yeah, we're making some progress. So no security clearance, sorry, and no advocate. So the next issue that you deal with in your statement is after this thing of being spied on, you say, oh no, before we leave that, you indicated that at some stage when you were dealing with, I think, CX, you had a document in London which arrived from SSA that you had given to DECO. Am I right? Is that a fair summary?
Yes, sir.
Yes. And why did you give that? Why did you not travel with that document yourself to South Africa?
Because the documents were bulky. These were documents from Mr. Otley, and the person whose name I have on the minutes on my minutes of the 15th of October 2015 had sort of substituted an investigator for me because I was alone in the meeting with Michael Otley.
Okay. So you gave them those documents away because they were bulky. That's
sorry,
basically
it was some of the bulky ones like liver arch, if I'm not mistaken, and I took the ones that I could take. But what we agreed, the bulk of the documents, it's a box. I didn't have that box. That box was provided by Mr. Michael Otley. I don't know what Mr. Michael Otley provided to parties, but I don't know where this is going to. But let's
yeah. No, okay. I think that's your problem, really. You mustn't worry about where anything is going to. Just answer the question. That's
I don't
all.
worry, sir.
Yeah. Yeah. Well. Yeah. Okay. Then don't tell us if you don't know where it's going. Because yours is just to answer questions. All right. Then you say at 9.6. We worked as a team building an executing system that tried to balance rigor with promptitude, gave priority to what we refer to as Gogo Dlamini cases, while ensuring that the investigation standard applied and the duty of care was uniform. This is a term that you've used again in the public domain, so even I would know. But just for the record, when you talk about Gogo Dlamini, you are indicating really, you are differentiating the ordinary South Africans as opposed to some of the high profile people that you deal with, just ordinary South Africans effectively with nothing much, correct? Yes?
Yes, sir.
Thank you.
Okay.
Yes. Now, we had here two Gogo Dlaminis, except that they were males. So I'll call them Kulu Dlamini. Both of them, or at least one of them, said that you took 11 years without resolving their problem. Would you categorize that as giving priority to what you refer to as Gogo Dlamini? And maybe before you answer, so that we save time, the other one was a real Mkulu, was 80 years old, and he was here, and as I indicated last week, he cried tears because he says you ignored him when he told you that he had been assaulted by a member of your staff.
Right.
Mr. Samuel, now, would you agree that, at least from the evidence before this committee, the Gogo Dlaminis that we've had testifying here have had only praise for Advocate Kobane, who in both cases intervened on their behalf, ordinary people, but they gave us horror stories about your lack of response to them. I'm saying that in relation to your claim of giving priority to Gogo Dlaminis. you would agree that, and I want to give you an opportunity to deal with it, that doesn't leave, that doesn't give us an impression that you prioritize Gogo Dlaminis. Actually, it gives us the impression that you terrorize them.
I knew you would want to insert this in the back door. These are two of the cases that I had objected to being asked about. And I asked, whose impeachment inquiry is this? Given the fact that these questions are about my conduct and they also are selective cases. But nonetheless, because you have decided that I am on trial, despite the fact that this committee said I did not need legal representation because I'm not on trial, I will answer you. We gave priority to Gogo Dlamini cases as an institution. And that's what my affidavit says. We gave priority to Gogo Dlamini as an institution. Giving priority to Gogo Dlamini does not mean you will submit in relation to each case at the time you choose to submit. For example, in November, or it was in December, when I was at UJ, a student came running to me in front of the other students and insisted she wanted to take a picture with me because I am the reason she's at university, because her mother was part of a group of employees that had been dismissed, that I gave the jobs back. I didn't know that. So it's just one example of Gogo Dlamini and of this child who I took a picture with because she has taken law because I dealt with their case. They were traffic officers, they were Gogo Dlaminis. So you selected the cases of Sarah. Sarah is a case of artists. As far as I recall, I did conciliate that. And why conciliate? Because we gave priority to Gogo Dlamini cases. If you look at my schedule as a protector, and this you can get because the diaries stay back there in the office, you will see that the majority of cases that I dealt with were cases that involved common people, despite the fact that we had an institution that was divided into the service delivery, its access to justice and service delivery, as the affidavit of Ms. Mokhaladi says. And my role was the overall institution plus special attention matters from any of the branches, from all of the provinces, plus the good governance in the property branch. But I still sat on those cases. I can talk about the Mahlangu. Better had transcended 3 public protectors. So you're going to say, if the Department of Arts and Culture did not implement the agreement on time, then that means I did not prioritize the cases.
Yes. Okay.
Logic.
Yeah. No, that's fine.
Logic,
but you would agree.
No, can I finish, sir? Even the very fact that I got involved was precisely because of prioritization, because that branch was the deputy. And at the time that matter started, my deputy was Advocate Shai. And then the other case was a human resource matter. Again, human resources, if you had bothered to ask for institutional documents, you would have found how the structure was shared between me. Again, that matter was dealt with properly according to the institution in terms of the procedures. And this person, you must show me, and I did ask you, who's accusing who? Provide me with the documents. You never did. And you talk about lawyers who know their stuff. Lawyers provide people with documents. They don't rely on ambush. If I accuse you, I write to you and say you're accused of 1, 2, 3. Here is the person accusing you. Here is the information, and you let people respond properly.
Okay, thank you, Chair.
If you haven't done.
Yeah. Well, are you finished now?
Yes, sir.
Okay. No, that is why, Madam, we were at pains to beg you to consult so that we could have put these things, but you rejected that offer. But be that as it may, you are now saying that making a person like Mr. Nyatela to wait for 11 years until the current public protector came to his rescue is you're saying that counts for nothing. It's he just had to wait for 11 years and forever. If your term was 20 years, he would wait for 20 years.
I didn't say that. There are matters that are resolved. This matter, for example, transcended 3 public protectors. And as far as I recall, because I don't have the information now, there was one resolution after the very first time I got involved. There was a resolution between the Department of Art and Culture and this person. And I haven't had an opportunity to get that information, but I do know that there was a resolution. But having said that, I am saying your effort is to try and to resolve these matters. And if at the end of the day, they're not resolved, it doesn't mean you haven't prioritized it. In the same way that there are matters that I have resolved, there are matters that come to me now where there was a finding of no wrongdoing. There's a case, for example, that I want because of the names of the people that I was dealing with, and my successor found no wrongdoing. And when I dealt with the department, we've moved an inch on something because there were clearly files were lost. And the finding was that there was no maladministration. Yet this person's files were lost. How can you say? So I'm just saying, when we're dealing with these matters, sometimes the outcomes are in the hands of other people. Yours is to make sure that you assign people, and when you personally need to get involved, you get involved.
Yes, okay, that's fine. I won't bother you with the gory details, but the evidence of Mr. Nyatela in front of this committee is uncontradicted. And I was just giving you an opportunity to deal with it, but you're telling me about students at University of Johannesburg who I assume also fall under Gogotlamini. But I'm going to ask you about the specific case then of Mr. Siabi, because you may be right that you rely on others and so on. Mr. Siabi, who cried here, said that he told you, not somebody else, that this person who is chairing your meeting assaulted me, and you said you'd talk to him after that meeting, and instead you just drove off to Tabazimbi, and he says the only thing you did was to take Mr. Samuel to the Free State, and there was never any comeback for his being assaulted by Mr. Samuel, and that's evidence is also uncontradicted. Would you agree that that doesn't demonstrate prioritization of Gogotlamini if you allow septuagenarians like that, who's now an octogenarian, to be assaulted by members of your staff?
Firstly, that's not true. That whole story is not true. It's also not true that that matter was never dealt with. Again, when this matter was put among the accusations that now made me the person who's being impeached, I did ask you specifications, and you shouldn't say to me, I needed to come for consultations. Earlier on, you asked me about my practices as a public protector. As a public protector, when people were being accused of things, we wrote long letters to them indicating specifically what are they being accused of and what do we know. And I do not understand, for you being highly paid, why were you not able to write specifically and say, what are you accusing me of? Because if you had told me what you're accusing me of, And if you had told me that you will insist on bringing these matters on, I would have then insisted on driving to Pretoria or flying to Pretoria to get these files of what exactly happened. But I do know that what you're saying to this committee is not true. It is just not true. You're abusing an old man. And I'm sorry about what happened to Mr. Siabi. We do know that there wasn't a matter there, but that matter was dealt with through a proper HR process in the project. The details of which I don't have at this stage, because I didn't know you were going to ambush me further with it. We did agree that the focus of this inquiry was going to be the two cases.
No, ma'am. Ma'am, your statement says you gave priority to Gogo Dlamini. It's not me who said that. So I'm simply testing the proposition that you make, if you don't mind. So the old man, if you are saying that he's lying, he was not assaulted. Well, I can tell you that there's a court decision that says that he was assaulted and Mr. Samuel was sentenced for that. And that's it. So it's not me if all that is made up. It's either Mr. Siabi or the court that found Mr. Samuel guilty. I was not even asking you about that. I'm asking you about your callous and cruel refusal to attend to Mr. Siabi, about which he testified here, you know, in a very sad way, and about an incident that involved you personally. And if you don't want to deal with it, that's fine. But please be assured
May I respond again, sir?
No, please allow Advocate Pofu to conclude.
Oh, okay, sorry.
So now I was saying, Madam, that the evidence of Mr. Siabi before this committee in that respect is not contradicted. And in relation, sorry, Chair, in relation to the issue that you raise of relevance, that is very relevant. This is just 1 second, Madam. Mr. Siabi, that you'll find it at bundle K, Chairperson, page 6456, if you can put it up. He was invited by the chairperson to make concluding remarks towards the end of his evidence, which, as I say, was quite, can be sure there was not a dry eye in this room when he told his story. He said, 6456, I want to thank you from the bottom of my heart, said to the chairperson. I know that now I will be at ease. I could not report people like Advocate Madonsela anywhere. You gave me a platform and I know that my case is being attended to. To which Honorable Siwela then said, Advocate Madonsela will be part of those who will appear at the honorable members. And as the honorable members have said, but we condemn the issues of violence. And to which Honorable Tlakude said, regarding Advocate Madonsela, we will handle that on your behalf. And to which Honorable Mola said, in that regard, is that Advocate Madonsela is due to come and appear before the committee. We will surely ask that question on your behalf. So there's no doubt about the relevance of what I'm raising to the issues that are before this committee. So all I'm saying is, do you have an answer or not to the allegations that you are complicit in the criminal assault of Mr. Siabi by Mr. Samuel?
Two answers. The first one is, this is another low, even by your standards. Firstly,
Chairperson,
you
please.
are making.
Okay, no, wait. Chairperson.
Okay, just pause,
Yeah.
Advocate Madonsela.
Chairperson.
Advocate Mpofu.
Yeah, I'm not going to tolerate this forever. If you allow this witness to insult me as she has been doing, then I'm going to have to deal with her myself. And it's not going to, it will be ugly. Let's just say on both sides.
Just pause there. Let
no,
me
it
attend
will
to
be.
the issue.
Yeah, I'm not here to be.
Yeah, let me attend
to be insulted by a witness.
That's fine.
And what is your problem, Mr. Myla?
No. Leave that.
No, you must not do that. Don't do that. Okay.
Advocate person. Advocate Mpofu.
Must not do that.
Advocate
I'm
Mpofu.
being assaulted here and he's laughing, giggling.
Advocate Mpofu. You know,
I'm being insulted and he's giggling.
Advocate Mpofu.
Please, Chair, protect me from both the witness and from the likes of Mr. Milham, the husband of the complainant.
I'll attend to both issues. The first one, let me start with switch off your mic, Honorable Milham. I didn't recognize you. I would want you when you to speak through the chair.
Yes,
so that we avoid.
No, sorry, I was addressing you.
I would want you to register that point and then I attend it as a chair. But the problem you attend to it yourself.
Yeah.
And it doesn't help.
Well, Chair, because you are failing to protect me.
Then you are making another statement, which is also not correct.
Okay, sure. I'll leave it to you.
I'm going to ask, firstly, Honorable Milham, let's keep our calm and not even try and interject. In the House, we do that, but this is just another platform about whatever was. If you have something to raise your hand and raise the matter so that we avoid this issue. I'm not saying raise your hand now. I'm saying when you have to raise something, that's what you do. I'm not there now. To Advocate Madonsela, maybe it might be important. I know that there's been a lot of exchanges between yourself and Advocate Mpofu to refrain from that kind of language of this is a law or another law from you. I would want that you tone down on that language.
No, Chair, I'm sorry.
So what are you doing?
No, I'm
on the platform. I'm not speaking to you even for that matter.
Okay, but that's not the insult.
Anyway, switch off your mind.
Okay, Chair.
So, Advocate Madonsela, I'm asking that you tone down on that kind of a strong language. I'm going to be asking everybody to do that in the process. Honorable Sukas.
Chair.
I've noted your hand.
Yes, Chair. No, Chair, you actually covered it that by saying that you are saying it to everybody. Because as I referred earlier, even the exchanges prior, the subtle intimidation of the witness has now twice, I think thrice, spoken of the fact that if she is if she is the subject here of the inquiry, that then she needed legal protection, or she should have consulted with her legal with her lawyer. So the issue here, Chair, is Advocate Madonsela is not the subject of our inquiry. She is not. And I would like it to be noted in terms of the time, because we have not progressed to the two cases that has been the focus of this testimony, why Professor Madonsela is before the committee.
Okay. Thank you, Honorable Sukas. I am watching that space, but I was also happy with the fact that some of the issues raised are arising from the statement.
Yeah.
So it's important that we don't just brush that aside. And Advocate Madonsela is competent enough to respond to those issues. But I take your point about issues of subtle threats and intimidation. Honorable Mylam.
Chairperson, I'd like to point out that I did not laugh at Mr. Mpofu. I made a comment quietly, and my comment arose because Mr. Mpofu threatened a witness. He said, I will deal with it myself and it will be ugly. And Chair, that is absolutely unacceptable in a committee of parliament. And I'd ask that you deal with that matter, Chair.
Okay. Chairperson.
Thank you, Honorable Mylam. As I also get back to you, I'm also going to be asking the same.
No, you can't ask the same, Chair. I'm the victim here.
Wait.
I'm being insulted.
Wait,
ask the same for what?
You're going to have to tone down your language here, Advocate Mpofu. You are not going to be treated special at any time. So whatever that I've just asked Advocate Madonsela to do, I'm asking you also to do that. You can't expect special treatment from the chairperson. I'm addressing both of you. Please proceed.
Thank you, Chair. All I'm saying, Chair, is that when I'm being insulted by the witness, you can't say that you are addressing both of us, because I've refrained the whole day. I've been patient. I did not insult this witness. I did not intimidate her. I'm simply saying that if you fail, as you have dismally, to protect me from her insults, then I'm going to have no option but to do it myself. It's called self-defense. I cannot be just insulted at will by anybody, including the witness, you, anyone, human being alive, okay? So my lack of response must not be mistaken for not being able to do so if I want to.
Yes.
Please,
Let
that
me just indicate this, and I'm going to say it once. Whatever self-defense you want to do outside of this inquiry.
No.
In this inquiry, there's a chairperson who directs proceedings and who does everything.
Who's supposed to defend us?
You might feel that you don't feel protected. I'm playing a role that a chairperson must play, which must be fair to everybody.
All right.
If we have to initiate self-defense, it will be outside of this inquiry.
Okay.
Thank you.
No, well, anyway, that's fine. Thank you. Madam, when you say even by my standards, what do you mean? What are those standards? Other than the intention to insult me and my professional integrity? What are the low standards you're referring to? Because that's not, the chairperson did not address the actual insult. I tried to assist him. So I'm going to ask you to answer that question.
You have insulted me, you have berated me, you have ambushed me, you have threatened me. That I considered low. But out of respect for you as a fellow professional, and out of respect to the chair for his ruling into this house, I have withdrawn the statement about it being low.
You've only withdrawn that part, but you don't withdraw the rest of it?
No, you have insulted me, sir. You have berated me. You have threatened me.
You have not insulted me? Have you insulted me?
Self-awareness.
No, I'm asking, have you not insulted me today since the morning, and I've appealed to the chair?
Sir, I didn't argue that I had not insulted you.
All right, that's fine.
You said you've not insulted me, you've not berated me, you have not threatened me, and I'm saying that's not true. You've done all of those things, and you've ambushed me which legally is improper. You understand administrative law, but if you are going to be accused of something, you need proper notice and time to apply your mind. You're asking me about things that happened 6 years ago with no information given to me now or in advance.
Thank you. All right. Anyway, I think as the chair said, everything I've asked you arises from your statement. Now, the other issue that you've referred to is the OR Tambo Declaration on Minimum Standards and Effective Ombudsman Institution. We had evidence about that from Honorable Zulu Sokoni, whom I understand you know her.
Yes.
Yes. All right, we'll come back to that one. I just want to go to the remaining third. As I said, your statement was 66% or 66.6% to be exact, made up of these sections that you called context, both of them. So let's deal with the remaining third of your statement, which is part B thereof. Now, you've testified that you were the lead investigator in the CX matter, correct?
At the beginning, as it says in the statement.
No, there's no such thing as beginning. It says, I was the lead investigator on commencement only, working with a trainee investigator. And when he left, the investigation was stalled until I was given a young investigator who had just been promoted to the status of an investigator. So in respect of both persons, you were the lead investigator, correct?
At commencement means the same thing as at the beginning.
Yes, ma'am. And then you say after that, after the commencement or beginning or start, the investigation, you were given another investigator who had just been promoted. Were you the lead investigator even at that stage, which was no longer commencement?
It was now at this stage shared because he did some of the work. And I was there only for, you see, okay, can I explain what is a lead investigator? A lead investigator is the person who will draft the rudimentary report. So before I had Advocate Livuani, I did the document drafting, and the initial document that I was consulting with was drafted by myself. But once I had somebody who was an investigator, that's why the report writing and scheduling of meetings.
So is your answer then that when you were given a young investigator who had just been promoted to the status of an investigator, that person was the lead investigator, or you?
It was a shared.
Okay. Were you?
Can I finish the answer?
Were you a co-lead investigator?
I would say that I wrote that it was an outlier because it had never been done that the public protector does an investigation. Because as public protector, you don't have the time to do that. So he was sort of the main, but with me there every step of the way. I think, yes, to say we were co-investigators would be fair, except that he was more main than me because the rudimentary documents now fell on him. Whereas when I was still with Tavernet, the rudimentary documents still fell on me.
But the investigation was virtually being conducted by you.
It was conducted by me and this young investigator who has appeared before this committee.
Yes, but your statement says the opposite, ma'am. You say it's 7.1. The CX investigation was an outlier in that it was the only investigation that was directly supervised by and virtually conducted by myself, which is just the wrong grammar. I'm sure you wanted to say by me, conducted by quote unquote myself as public protector. I'm saying that is that a statement of fact, or are you now changing that?
So that's again, those slides, when we start talking again about pointing each other's mistakes, just be sure that you have started again and don't be offended if it's brought back. Okay. As I said, it says virtually. So virtually doesn't mean exactly.
Why are you threatening me now? With bringing back whatever you want to bring back.
I'm just letting you know that virtually means exactly that. Like I'm with you now, virtually.
No, come on, doesn't mean the same thing. That's okay, that's fine. But you accept that the investigation was virtually conducted by you as the public protector.
Yes, that's what I've said, sir.
Right, yeah. Okay, so no, it's what you did not say, but I pointed it out to you, it's fine. And then that, as far as the CX investigation is concerned, then made it, quite frankly, unprecedented and even unsucceeded, because I can assure you that I don't think any other public protector, including you, had ever conducted an investigation at that level, or even after you. Now, so you might want to explain to the committee why such a, okay, sorry, let me ask it like this, madam. Would you agree that as a matter of policy, it is undesirable that the public protector himself or herself does the investigation, but that is better for them to supervise? That's the structure of the act.
No, that's not true.
Okay, so you think
That's
it's
simply
quite
untrue.
So all right. So why then has it never happened in the history of mankind that the public protector investigates himself or herself at that level? And you said 7.2 correctly. Before then, no investigations were conducted from my office and no other was. So why was that practice or policy or culture developed?
Okay, when I say before then, I meant during my time. So I'm sorry that I didn't explain that I'm talking about my time, that before then, I had never conducted an investigation. I had personally done investigations before as public protector. And after this, there was no other investigation that was conducted by myself. I cannot speak for what happened under Advocate Mushwana or Bagwa, who dealt with the arms deal and other investigations. I would be lying if I said I know that they never conducted any investigation.
Okay, but at least you know that you never conducted an investigation before the CX one.
I said so. Even the virtually that you now claim to have corrected me, it is in my affidavit, sir. I said so in my own affidavit that this was an outlier. An outlier is an unusual thing, something that is out of the ordinary, because it came out of extraordinary circumstances.
Yes, yeah, that's what we're getting to, ma'am. I'm saying that an outlier is like an exception to the rule, correct? Yeah. I'm saying this was not an outlier as such. It's something that had never happened either before or after the CX investigation, at least during your term. You're quite right that you might not refer to other people's terms, but it was unprecedented and unsucceeded by anything like it, correct?
was reportedly an outlier. I hope you don't intend for us to get dictionaries to define outlier.
Okay, let's, I thought I'm avoiding, ma'am, the dictionary. Let's just use simple English. Before this investigation or after it, you had never conducted an investigation yourself? Yes?
In the office where I do the groundwork, yes.
Thank you. All right. Now, and now let's go to the reason that you give at 7.3. You say the reason for the anomaly was that the request by Advocate Paul Hoffman SC, sorry, to have this investigation conducted was rejected on grounds of the fact that the matters it dealt with preceded the genesis of the public protector. Who rejected it?
There was an intake and assessment committee, and then it also then goes to the think tank. So it would have been rejected by one investigator, and it went to the team, which is the assessment committee, and then it would have then gone to the think tank that also said no. Okay, so effectively, that's what happened. This was rejected by an investigator applying the policies of the organization, and also rejected by the think tank. And you basically overruled both those structures, well, the person and the structure, correct? I did, but this is what I did. Of course, you go back to the committee and say, there's additional information. What you didn't pick up is that there's this statement and the statement that I made this morning. It wasn't just they made a decision and then I overruled it. It was a decision was made. Then I traveled to Barcelona and met Advocate Paul Hoffman, who gave me additional information. And then I asked him to supply the additional information. And given the workload that people were already battling under, and the fact that at this stage, he seemed to think that there was no investigation that was going to be required, I then took it. So it wasn't just overruled arbitrarily. It was after additional information, I was persuaded that this could be done. And you did not think it would be? Yeah, yes, no, I know that. You did not think at that stage that you should have then taken it back to the people who rejected it? Well, of course it gets taken back. You don't just make this arbitrary decision. Nothing was ever done from my office. It still goes back to the registry, but I request that we accept it on the grounds that I am going to do it. So it didn't just go into a little corner in my office. It went back again. Advocate Paul Hoffman, that's why you'll see the new request is late dated. I think it's not dated in 20. Oh God, I'll have to look at my notes. He had to resubmit the investigation. But again, that we can get from the files from Mrs. Sigele, who was responsible, I think, at that stage for intake, assessment, and customer service. Nobody did things in the little corner during my time. Okay. Okay, so if whether it was a little corner or a big corner, the issue is that you're saying that there were also concerns regarding the efficient use of resources given the lapse of time, making this a cold case compounded by prescription rules regarding the recoverability of the relevant funds. So not only was it rejected on the basis that it preceded even the promulgation of the Public Protector Act, do you think you have a right to conduct an investigation
for a matter that even precedes the promulgation of the act?
No.
Let alone about the 2 years thing for now.
No, definitely I don't. That's why my original report does not read like this report. I never investigated whether the gift was a gift, whether it was a lifeboat, whether it was a loan, whether it was corruption or not. No, even though some witnesses took me through that, like Judge Bertelsmann and others, I was clear that my investigation was what happened in 1998. My investigation was not whether it was a loan, a lifeboat, theft, or gift. My investigation was simply on receipt of the CX report. Did government act properly? And I had been made aware that it was not going to be an investigation at that start. It was the thinking or the impression that I was given by Advocate Paul Hoffman was not. It was going to be something that is almost like a mediation. By the way, with public protector investigations, when it's conduct failure, it would not be mediated. But if it's a service failure, then it could be mediated.
Okay, you've just said that your investigation was not whether it was a lifeboat or a gift. I'm putting to you that that is false.
Well, you can put it to me that it is false, but I will tell you that I didn't investigate whether it was a lifeboat or a gift. I was investigating the conduct of government at the point at which the CX report, that's why we called it the CX investigation, because it was all about what happened. In fact, I can share you my notes with Michael Otley. You will see that my concerns with Michael Otley, with all of these people, actually, my concern was about what happened.
Yes. Okay,
can I just finish the sentence? What happened when Michael Otley approached the government of South Africa as a bounty hunter, so to speak? And what happened at the point at which he submitted this report, which was different from what he was contracted for, by the way, but I still wanted to know what happened, and if what happened is not what should have happened, and then the implications financially thereof. It was always with the view that possibly some mediation would take place in this matter, which was my style, by the way, on some of these matters.
Okay, thank you, ma'am. I'm just going to ask you one thing. You've now twice said this here. Now, can you tell us, you know that you had that well-known style of naming these reports, secure and comfort, and those kinds of things. What did you call this one of CX?
We hadn't named it yet. Remember, I didn't leave an approved provisional report.
Yeah, okay, I'll tell you when you come back that you named it lifeboat or gift, which is what you are saying you did not investigate, but we'll deal with that
Thank you.
After tea.
Thank you, Advocate Mpofu. Thank you, Advocate Madonsela. We will pause for 10-minute break for tea and back 8 minutes to 4. As we finish our teas where we're sitting, let's proceed. Baba, leko hlula ucango. Aw. Ukuthembeka ngakho. Yeah, no, I finally got you. Thank you. Welcome back. Over to you, Advocate Mpofu.
Thank you, Chair. Ms. Madonsela, I was showing that the report, you know, Advocate Chiwalule.
Yes, sir. He was the investigator that I ended up working with.
The young one.
Yes. Brilliant young.
Yes. Now, he told us that the draft that you left behind, and to be fair to you, you did say that this was not a provisional report in the sense that it was an approved one. I take that point. But that the draft that you left behind, because as we know, you did not finalize this report contrary to your intentions to do so by the time you finished your term, correct?
Yes, sir.
Yes. Now, if you go to, okay, Tsepo, you're going to have to help me here. Advocate Chiwalule's statement, it's bundle D3. I want specifically to go to 3222. I'm told it's item 15.
Okay, you can flight it.
But all right, just go to the end. We'll come back to the beginning. Just go to the right at the end. Sorry, but that's 3279. So that's the draft, which, as you correctly pointed out, you did not sign because there were still outstanding issues and so on. But it indicates your name and his, correct?
Yes.
Right. Now, you testified before T that you never investigated whether this was a lifeboat or gift. And I was telling you that that is false. And if you go to 3222, do you see what name did you give to that report at Roman 1? Can you read it out?
This is a name that was given by Advocate Chiwalule. You went to the end of the report, Advocate Mpofu. All public protector reports look like that, regardless of who investigated them. It has the name of the public protector and the name or names of investigators as assisting parties. So that doesn't mean it was my report. In fact, reports that I hadn't seen would have had the same ending. So that's not true. That's simply because Advocate Chiwalule, who states very honestly that I had asked him to go in and fix certain things, but also it was my style that after they fix certain things.
I think she's gone.
Are you there? You are muted. You are muted, Advocate Madonsela. Unmute yourself. You are muted.
I think somebody else muted me. I was just finishing a sentence that my style, which can be confirmed by everyone, is that once they had written and I had made certain comments of things that they themselves can change, then the final report would be done by me, and literally sitting behind my laptop, modifying language where appropriate. And of course, then it would also still go to the quality assurance team. It would not go to the think tank sometimes if it's a SEM, but it would certainly go to the quality assurance. So I didn't investigate the lifeboat, but here's the thing, sir. The fact that the title says lifeboat or gift does not necessarily mean you investigated the essence of what happened. You are still investigated the essence of if let's say it was a lifeboat, why was there no collection? Because all we were looking at, and you will see with the set of questions that we asked, and I refer you to what is online now is my interview with Chris Stolz. It's fully online. And then you will get what I said to him. I was investigating because he had been the governor of the Reserve Bank at the time this happened.
Ma'am, okay, just pause, Advocate Mpofu. Advocate Madonsela, firstly, before I intervene as a chair, I'm going to ask you, Advocate Mpofu, because once you start that conversation, you remain in charge of that, so that when you ask when you wanted to pause at a certain point, you have to do that or indicate. It's only when that is not happening, then I'll come in, but I don't want to disturb the flow between the two of you.
Yes, I understand that.
Yeah.
Okay. Ma'am, do you even remember what the question was? Or what I asked you to do?
The question was, it wasn't a question, it was an accusation that it's not true that you say that you did not investigate the lifeboat. And I say that you are the one who is incorrect.
Yes, no, it's fine. I think, no, it's understandable. You forgot what the question was. And I don't blame you. All I said was whether you could read what the title of the report was.
I can read the title, and then you accused me of being responsible for that title, and I was telling you that no, I was not responsible for the title.
All right. Now, okay, let's do it like this. When you receive this draft, let's go, I'll just take a random example. And I think you've just described it. Go to 3242, Tsepo. Yeah, the bottom. So at those remarks on the right, those would be your corrections and additions, correct? Or your comments?
No, these are cosmetic comments by someone, not me. I don't.
When you say, what is the figure? Well, according to Advocate Shaulule, he sent these drafts to you and you were working on them. And he agreed with you that you had not finalized, you were still raising certain issues. So he never said he sent it to anybody else. So those comments would be yours. And according to your evidence, it was only you and him, you were the co-investigators. So let's not waste time on this. Those reports, those comments were yours, correct?
If they're mine, they would say that they're from me. Usually the computer says whose computer is it from. My comments were extensive towards the end, and they were not cosmetic.
All right. Okay, that's fine. If there were only two of you.
So I don't know which version is this one. It's certainly, I wouldn't have done the cosmetic.
All right.
But I also don't understand where this is going, because the Constitutional Court has ruled on this matter. Are we going to try and review that ruling?
No, we are not going to. And I told you earlier, as a witness, it's not your duty or obligation to say where the questioning is going. That's my duty. Yours is to answer the question. All I'm saying is that what you're saying now is startling, to say the least. You testified that this was a so-called outlier, and that means that you and Advocate Chalule were co-investigators and nobody else. That also coincides with his evidence. And now I'm saying to you, there is a comment, for example, at 3242, which says, what is this figure? Something about 1.5 million. So he could not be asking himself that figure, that question. If
Did you ask him? Did you ask him who asked this question? Because
yes, he did say. Yes, he said, like you said, that it was only the two of you. So
no?
Who else?
He specifically said in his statement, sir, about on his last day, 3 days before I left office, he submitted the final report, which I responded to. So where is that version? Because that would have been the only version that should be material.
No, ma'am. Okay. You know, really, I think you're just
that is in his statement, sir.
Okay, all right. In your estimation, just as a matter of logic, if it was you and him only involved in this, and he made a draft, and the other person commented and asked about figures, who else could it conceivably be other than you?
Towards the end, he does say that towards the end, some of the quality assurance people, we would ask them questions. And I wouldn't be surprised if he asked somebody who was a quality assurer these questions, because this is more technical questions. My questions were substantive questions.
All right. Anyway, the point I want to make is a simple one. When you received these drafts, you made comments yourself. Let's assume these ones are not yours. You made your own comments, correct? You did?
I did. And usually by hand, actually.
No,
usually it was by hand.
Yes, okay. And in none of those comments that you made, did you change the name of the report from lifeboat or gift, correct?
We changed the names at the end, and that you can confirm with the team. Because that was not, we were not in a hurry. Some of the names would actually change hours before we release it, like secure in comfort. The answer came as so no, we wouldn't be bothering about names at that age.
Okay, all right. So it would seem therefore that your evidence that you did not investigate whether this was a lifeboat or gift is false, because that's exactly what it was. That's the first impression, or the very first 3 words.
May I just clarify once?
Yes.
You asked me when we started that with this matter having been rejected by my staff, a proper intake and assessment team, with me having signed, because when they reject, they don't just send it. I sign and I agree to the rejection. Why did I investigate it? The only way I could investigate it was if there was a coincidence between our remit and what we were trying to do. And you must realize that, as you can see in the report, we interviewed so many people. They themselves would ask us, what allows you to investigate this matter, given the fact that you were not born before it started? And then would explain to them that we're investigating from 1998. And I have said to you, instead of me and you hagging and tackling about what exactly was I investigating, one of the key people that unlocked this matter was Chris Stolz. My interview with him is fully online. Just check it out.
No, that's fine. That's your answer. That's your answer. I was just pointing out to you that that was the title of the thing. That's fine. Then you say at 7.4 that you were persuaded to take this case on, irrespective of all these weaknesses. When the complainant, that would be Advocate Hoffman, assured me it would be a slam dunk. Now that's slang for saying it would be easy. It would be something that was not going to take long, correct?
Yes, I apologize for the language there.
No, that's fine. I think we all know what that slang means, yeah, but it's fine. There's a whole thing about slang in affidavits, but that's fine. Okay, that it would be a slam dunk in that there were documents indicating that the debt as admitted and funds set aside by the bank at the center of the complaint. I don't know what that means. What were you trying to say there? You wanted to say where at the center of the complaint?
I was persuaded to take it when the complainant assured me that it would be a slam dunk in that there were documents indicating that the debt was admitted and funds set aside by the bank at the center of the complaint.
Yes, no, I understand that. I'm saying how can that make any difference? If it's illegal, or rather if it's against the act, or if it predates the act, whether it's a slam dunk or not a slam dunk, cannot be a reason for you to investigate something that is that falls outside of your jurisdiction.
That's why I have explained to you that with the conversation that I had, it was very clear that I'm being asked to investigate the CX report, not. Okay. And that's why it kept being regarded as a CX investigation, because it was all about what did you do with the CX report? I mean, I can show you my notes with Billy Masetla. The focus on it, there's no way where I even asked anybody, why did you give away this money? Some volunteered the information about the money because they had done the work already, like Justice Dennis Davis and Bertelsmann. But everyone else was asked about 1998. Only.
Okay, ma'am. All right. And then you say that the matter ended up being, you didn't answer my question, but it's fine. Let's move on. The matter ended up being far more complicated, though we persisted even after loss of time after the trainee investigator left. So even when it became clear that it's not a slam dunk and it was more complicated, you continued to spend money on it, correct?
I did, because...
Yes, thank you. No, I just wanted to know that you did continue, yeah.
I don't like these hanging questions. You, not me, insisted that context is everything. You didn't even allow me to explain that it's not everything, it's an important factor. Even if Justice Kampempe said something about it, that was in obiter, not res. Not reason.
You want to say ratio decidendi? Yeah, that's Latin. It's very difficult. So, okay, that's fine.
You love actually getting these small jibes, eh? They make you feel a little bit more competent.
I'm assisting you. You wanted to find the words ratio decidendi, the reason for the decision. Yes. Yeah.
But I was in the process of saying that, and then I thought that for other people, it's important that they understand there's a difference between a comment and a reason for decision. And what Justice Kampempe said was not reason for decision.
So that then, I mean, that's okay. Let's not go there. You want to debate stare decisis with me? Oh
yes, you've just missed it actually with the case, with the one case that you insist on, the one about the affidavit. So you've just missed it.
Okay, that's fine. That's fine. It's not okay. let's not go there. Let's not go there. You and I, if you want me to explain the principles of stare decisis, the ratio decidendi and the obiter dictum has got nothing to do with what we're discussing, but that's fine. So you say the matter ended up being far more complicated, though we persisted. I'm simply saying that you rather, even after you realize that it's not a slam dunk, you decided to proceed with it. That's really just a simple issue, yes or no?
I had answered, and then I said to you, I must explain. I don't like the hanging.
Okay, go ahead.
Yes, so I did say, yes, there were reasons to proceed because I still saw the prospect of some success. And at that stage, it was the prospect of some kind of mediation on this matter, of negotiation of this matter. If you know that the powers of the public protector include conciliation and mediation, and on matters like this, that was being considered. And in fact, that's what I was beginning to put forth on many of the parties that I was talking to, because I knew that if we're talking legality, we would have problem. But if we're talking morality, there was room for moving forward.
Okay, let's do this, ma'am. Before we get way laid into topics that are going to get one of us into tight corners. Let's go to your next paragraph. What you say? You say you left no final report or approved provisional report. We've established that.
Yes,
correct?
sir.
Yes. So, and you are familiar with the principles of the male and guardian case. Because of time now, I won't be able to take you through them. But effectively that the public protector is not bound by the four corners of the complaint, and he or she may broaden or limit the complaint. And in fact, the best example of that is the fact that the public protector, in terms of the act, can even start an investigation without anybody's complaint.
Absolutely.
Good.
By the way, I'm the one who wrote the public protector's standard operating protocol. It started with using the male-in guardian as our training tool.
Yes, good.
Discussing it as a team, extracting those principles initially as guidelines, but later extrapolating them. And I got one of the investigators, actually, if it's not Matlawe, I can't remember. Or it must have been Ticheli. And then we extracted them, and they are in the standard operating protocol that I drafted. So I wouldn't not know the male and guardian principles.
Yes. No, nobody said you don't know. In fact, I said the exact opposite. I don't know why you want to be defensive about it. I said you are familiar, of course, with the male and guardian. And then I went on to explain what it says. I was just asking you whether my summary was a fair one about...
It is fair.
Pardon?
It is fair.
Thank you. And therefore, if that's a fair, and this is now for the purposes of the absent Ms. Mazoni, who's not here, or who's being kept away. So it would be, I'm trying to say this in the most charitable way, it would be, I can't find another word, nonsensical to accuse the public protector of broadening the scope, because that's exactly what male and guardian says you are entitled to do. You can broaden the scope of the investigation, you can narrow it, and you can even invent it. I'm exaggerating. In other words, you can investigate when there's no complaint at all, correct?
I wouldn't say it's nonsensical. It would depend on context, and I wouldn't say context is everything, but I would say we would want to know what is the narrowing, what is the expansion, And again, this is a matter that has been ventilated in court.
Yes. No, let's not go to the court. I'm asking you now. It's not the court that is on the stand. I'm saying that generally, we in terms of the principles of male and guardian, the public protector has wide powers to broaden the scope of a complaint, to broaden the scope of any investigation, and to narrow it. And I'm saying, to illustrate that point, he or she has even the scope to create an investigation when there's no complaint at all. That's the essence of male and guardian, correct?
I didn't read male and guardian to say you can broaden the scope. I understood the male and guardian to say there's no barrier to how far you can go to find information. For the people who don't know the male and guardian case, this is the so-called Oldgate case, which I got to litigate. That's why we have this jurisprudence, taking it over from my colleague, Mushwana. And the issue there was not about broadening the scope of an investigation. The issue was about self-limiting. When the public protector didn't follow the money when it went with Imvume, and saying that that was now outside the scope of the public protector because it was outside state entities. So I don't think the male and guardian principle is about broadening the scope of an investigation, unless you read it differently, sir.
Really. Okay, so you don't think male and guardian, which says that there could be effectively a complaint about, let's say, a car. And if the investigation then leads to a bus and a train and an aeroplane, and I don't know what other mode of transport, then that's what you must do. You won't be, unlike a court of law, you won't be limited by the four corners of the pleadings or of the complaint, but you can broaden it in the sense that I've just explained, in that if the evidence leads you to the bus and the train and the aeroplane, you investigate that too. You don't regard that as broadening. Let's say an investigation.
My understanding, which is what we put in our investigation standard operating protocol, is that you've got to follow the evidence wherever it has gone. And that you've got a lot of powers and you should not self-restrain. But you're right that the powers of the public protector include the power to investigate both what is alleged and what is suspected. But for me, with my team, when I trained them, which is the same training that is given in Canada, etc., and in other places, is when you investigate, you have to still be clear what is the issue, what is the evidence, and what are issue creeps.
All right. Okay, and you say you wrote a manual on male and guardian.
No, I wrote the manual that the public protector is using, and the male and guardian case was the basis of how we started our training each other on what is a proper investigation is determined by the public protector versus male and guardian as decided by the SCA.
Yeah. All right. No, that's fine. I think we'll at least we had some expert witnesses who correctly interpreted the male and guardian case. That's fine. And anyway, people can read it for themselves. It's not a very complicated case. Yeah. Okay, so you've already testified about the SSA issue and the shenanigans that happened in London. So let's just go maybe to the gist of what you say in G. I'm Chairperson, I'm at paragraph 7.6, which is on the third page. The pages, your pages are not numbered, Professor. So it's paragraph 7.6 at G. You say there, and I suppose this is the culmination of what you want to say about this. Key changes that I've observed in the final CX report include the remedial action regarding changing the powers of the Reserve Bank, which was not an issue as the issue concerned lending and debt collection practices. Where did you see those changes?
In the final report, the issued report.
Where did you get that?
In the remedial action. Okay, do you want to fly to the report? I don't have it now.
No, I don't.
The report.
I don't want to flight it. I'm asking you, there's nothing to flight. I'm asking you, when you say the key changes which you observed,
yes.
It was in what was that? You observed them where, on what occasion, for what reason, and so on.
You see, if you had asked me in advance, I would have flighted the report. So I'm going to paraphrase the report. The final report deals with the need for an instruction to Parliament to change the powers of the Reserve Bank. This investigation was only about the lending practice and debt collection, because when you lend, you've got to collect the debt. And I've already indicated here that from the evidence that we got, the interest, though agreed as collectible, had not been collected. So there was nothing beyond that in terms of what we were remedying, because in each report, you ask what happened, what should have happened, is there a discrepancy? And if there's a discrepancy, has somebody suffered an injustice, and how do you remedy it? So there's no remedies that just fly from the blue. Your remedies are determined by that logical framework of what happened, what should have happened, is there a discrepancy?
Okay.
And to the extent that there's a discrepancy, was there harm caused? So the remedy is to remedy the harm. That's why you call it remedial action.
Yes,
so
thank you very
remedy much. If there's no harm that has been caused in your findings.
Okay, please try and limit your answers to my question. I've not asked you any of what you're talking about. I'm saying, maybe let me just explain what I'm asking you and why I'm asking you. When you say you observed the final, that includes the remedial action regarding changing the powers of the Reserve Bank and so on. Because there's no such thing in the report. I was just establishing whether you established it from newspapers, from whatever it is, or did you actually read the report itself? That's all, really, ma'am. It's really that.
So if you say I am lying and I did not
no,
read
I'm not saying you're lying, ma'am. I'm asking you, where did you observe this from? I didn't say you're lying.
It is in the report. I'm saying it is in the report. So
you observed it from the report. So is your answer that you observed it from the report?
You keep asking me,
and
then as I'm speaking, you
Can I ask?
I can't.
I don't understand. Do you want me to answer, or do you want to answer yourself?
Just hold back, Advocate Mpofu. Can you complete the answer on the, Advocate Madonsela?
Sure.
Right. My reading of the report is that that's the remedy. One of the remedies is one of the changes is the requirement as a remedy that the powers of the Reserve Bank be changed. That's my reading. I don't
Yes.
have the exact wording right now, but if you want me to look for the wording, I can quickly scroll into my documents, find the report, and then
I'll
flight
put it up. I'm going to flight it, ma'am, when we come to that. We are not there. I've asked you a very, very, very simple question. Where did you make these observations? Was it from a newspaper or from the report itself or from
the
a radio
report itself,
interview? Thank you. That's all. Okay. Now, if it was from the report itself, then I'm going to ask Tepo to flight the, and you say, Tepo, it's at page 69 of A1, I think. And you're saying that there was an instruction to who?
Where did I say there was an instruction?
You just said it 5 minutes ago in that long speech you made. You said there was an instruction to Parliament to change.
I didn't even mention Parliament.
Okay, you didn't say there was an instruction.
I just said there was a remedial action to change the powers of the Public Protector. And then
Yes,
my long story was about, for every wrong, there's a remedy, but there's a logical framework to how you arrive at the remedies.
You didn't use the word instruction in what you said.
I don't remember using it. If I did, it's so weird that I've forgotten that. But of course, we're on record.
No, the whole thing is weird, but I'm simply saying you did say it was an instruction, but that's fine. Let's not quibble about that. Whether you said it or not, the record will speak for itself.
I don't remember saying it.
Did you read an instruction from anything that was said?
I never used the word instruction. I used the word remedy.
Okay. I'm not going to argue with you, ma'am. You did use the word instruction. And as I say, the record I will send it to you once it has been transcribed. But so what are you saying now? Was there an instruction or no instruction?
I am saying there was remedial action. I haven't spoken about instruction. I spoke about remedies, remedial action.
Okay.
And I said there was remedial action about changing the powers of the Reserve Bank.
Okay, ma'am. Well, I'm sure you'll somewhere on social media, it will be played for you that you said the instruction. So we don't have time now. So, all right. But whether you said it or not, you are saying that there was an instruction. Oh, okay, are you saying there was an instruction or no instruction? Now, forget about whether
there was remedial action. Can we stick with my language?
Yeah, but I'm asking you
language into my mouth.
I'm not. No. Then you don't understand what I'm doing. I'm asking you questions. You can. I don't have to stick to your language. I'm the one who's asking questions, so I use the language that I choose. I'm asking you whether. And I'm not saying you said it or you didn't say it. The record will speak for itself. I'm now asking you afresh. Did you read any instruction in what the Public Protector put as remedial action or not?
I wasn't looking for instructions. I was looking for remedial action.
All right. Now, you would agree that one of the things that Mail and Guardian and I think the EFF and Nkandla case also says is that the Public Protector, the wide powers of the Public Protector include going to what he or she regards as the source of the problem, the root cause, I think is the words that are used by Mogoeng. Correct?
Yes.
Yes. Now, and you therefore agree that if the Public Protector regards in his or her wide powers the root cause to be X, then that root cause has to be addressed, correct?
Yes, absolutely.
Good. Okay, now we're getting somewhere. Now, in this case, the Public Protector identified the root cause, and she, not you, not me, was the public protector, as including what she said at 5.3.227, that's page 65, which was that the Republic has an obligation in terms of the Constitution and international instruments to improve socio-economic conditions of its citizens through legislative and other measures to alleviate poverty and ensure social justice for all South Africans. Government must realize economic rights to its people. And then she goes on to say the decision not to recover is seriously prejudicial to the people of South Africa, particularly the poor, who would have benefited through social development programs. You don't quibble with that, correct?
I do. I would have put it differently because with the investigation that I did, I think I have no quibbles with this, but do you want me to give you a bit of context?
No, that's fine. If you have no quibbles, that's good enough for me. So, okay, then I'm now saying that the public protector, rightly or wrongly, because she's the public protector and not you, not me at that time, having identified as part of the root cause, the mandate of the Reserve Bank, then made the remedial action that you're referring to. And I'm going to send you there. It's on page 69. It's the one to the Portfolio Committee on Justice and Correctional Services. That's a committee of parliament. This is the one that caused all the hullabaloo with the chattering classes and those types of people. So she says, the chairperson of the Portfolio Committee on Justice and Correctional Services must initiate a process that will result in the amendment of Section 224 of the Constitution in pursuit of improving socio-economic conditions and citizens of the Republic. You understand, okay, you may not know the processes of Parliament, but a process, you know that a process which is aimed at amending something like the Section 25 of the Constitution, the process that we had 2 or 3 years ago, is something that is allowed, but it may not result in an actual amendment. Do you understand that? Just as a constitutional scholar or understanding of how our parliament works.
I do, but I think there's a word that we are forgetting there, must, on line 2 of what you are flighting.
Yes.
I think when we are finished with this, sir, please allow me how I understood, because you're now asking me to second guess my successor. All I had confined myself to what changed. I didn't say what change was right or what change was wrong. That's up to this committee to make that decision. It's also been up to the courts. What I can do as your witness, sir, is to explain to you how I dealt with powers of the public protector versus things that I observed as a public protector, but that were not in my remit. Again, understanding my powers long before the Nkandla judgment, but understanding my powers correctly.
Yes, no, that would be very interesting, but if you can just stick to the answer my questions here. So if we get time, we'll get to that interesting debate. I'm saying, do you know what a motion is in Parliament? A motion is like a proposal, correct?
Yes, but it's by parliamentarians. Must.
Yes.
I think the issue for me is the word must.
No, just answer the question, madam. Do you know
Yes,
that?
I understand what's a motion.
Proposal?
We are on a motion right now. The trigger of this process was a motion, sir.
Exactly. So that was a motion of Ms. Mazoni, correct?
A parliamentarian, yes.
Yes. And so that motion is then a proposal. Parliament could have rejected Ms. Mazoni's motion, correct?
Exactly. You're
Right.
very correct.
Okay, good. Now, the public protector then says, yeah, the pursuit of socioeconomic by introducing a motion in terms of section 73(2) of the Constitution in the National Assembly, and thereafter deal with the matter in terms of section 74(5) of the Constitution. So that would be, as you correctly say, like the motion of Ms. Mazoni, it would be tabled in Parliament, and it would either, if it achieves the correct majority, it will succeed. If it doesn't, it will fail. That will be the end of the matter, correct?
Yes.
Thank you. Now, then the rest of it is then the proposed wording of that amendment, which may or may not, with you and I have established, may or may not succeed. And it's a banal or a harmless thing that says, the primary object of the South African Reserve Bank is to promote balanced and sustainable economic growth in the Republic while ensuring that socio-economic well-being of the citizens are protected. You wouldn't quibble with that as well, correct?
I would quibble with what is it doing here?
No, ma'am.
If one of my investigators brought a draft with this, I would ask, what is this doing here, say? Number
Yes,
one, our power
yeah,
to instruct Parliament. Two,
yes, ma'am.
what are we remedying in terms of the wrong we were looking for and our findings about that wrong?
Yes, but you're taking us back now. I said to you earlier, and you agreed, that the remedy is for what the particular public protector, not you or me or anyone else, regards as the root cause. So that public protector is not going to ask that question. You might ask it because you might have a different root cause. I might ask it as well because I might have a different root cause. But a public protector who has identified as he or she is entitled to do a different root cause will not ask that question, correct?
But the public protector, and so we're now talking a hypothetical, a reasonable public protector, not, so a reasonable public protector would have contested inside the report why this is an issue. It couldn't just randomly pitch at solutions.
Yes, ma'am. And that, okay, if you just listen, you know, one of the attributes of a leader is to listen. I'm saying to you, I'm not talking about a reasonable public protector or an unreasonable one. I'm saying to you, this public protector identified as the root cause, rightly or wrongly, let's put that aside, identified as the root cause, the issue of the mandate of the Reserve Bank. And we've agreed that she was then suggesting that there should be a motion in that regard. So take that as for granted. So that a public protector like that is not going to say, what is this doing here? Because he or she has already identified the root cause, rightly or wrongly. Do you understand that? Do you grasp, do you understand that notion that
no,
a person—
I don't, sir. On the
You
one
don't?
hand,
Okay,
you want
fine.
me to
No,
put
fine,
me
then
the
let me
in
not
the
bother
shoes
you.
of this public protector. On the other hand, you don't want me to use my brain. I therefore don't understand what you want from me, sir.
No, that's fine. That's fine. No, you don't understand. I think that's, we'll forgive you for that. Yeah. But anyway, let's now talk in broad terms of the Nkandla report and the Mail and Guardian report, or rather judgments, sorry. I don't have time now to take you through Mogoeng CJ's judgment, but you know that in that judgment, as well as the one that you and I were involved in, your very last one, which was state of capture, that the wide powers were affirmed in those two judgments, correct?
Absolutely, sir.
Yes. And in fact, just maybe anecdotally, so that people can understand where you and I come from with this, without the intervention of the parties that were represented, the state of capture report might never have seen the light of day, correct?
Certainly, sir. And we thank those parties. Our country would continue to be under the grips of severe state capture, which is still in, but not that severe.
Yes, that's fine. That's fine. All I'm saying is that the state of capture report which was released literally on your last day. There would have been no Zondo commission and all these things had we not intervened at that moment. There might not have ever been a Zondo report, correct?
No, sir, it's not true that it was released on my last day, because President Zuma litigated and I left without releasing the state capture report. It was released much later. Thank you.
Yes, but it was litigated upon on the 13th of October when you were leaving on the 14th. So had that litigation been successful or not opposed, then that could have been a successful, you know what I mean? If it was successful, it might have led to a situation where we might not have had the Zondo commission and all what followed. We know what followed. You're right. On the 3rd of November, actually, it was released by the court to the hands of the speaker, and you were already gone. So that's fine. I'm addressing something else. I'm saying without that intervention, because that was released by a court order, then whatever else followed would not have happened, correct?
That's
yes.
true.
Thank you. All right. And in fact, I can tell you for free that you have Honorable Malema to thank for that, because he's the one who made us not to sleep the whole night to make that intervention. And
I'm grateful to Honorable Malema, and I'm grateful to every human being who made sure that as a country we push back against impropriety, and grateful to you for your role too.
Thank you. Thank you very much. But as it were, and this is something that I just wanted for you to confirm, because there's a fixation sometimes. You spoke very well, and I agree with you about the balance between fairness and rigor. In other words, you can't just chase deadlines. You also have to make sure that in the process you produce a quality product, correct?
Yes, sir.
Yes. And that lesson, I think, can be learned then from that example that you and I are talking about. The reason why you wanted the Commission of Inquiry to be set up was because you had estimated that that investigation would cost 130 million and 6 months. You did not have the 130 million, correct?
No, that's not correct, sir. I think we had asked for only 6 million.
Only how much?
You mean from our side? The investigation
yes.
done by the purport, we asked for 3 million. We didn't ask for 130 million. We asked for only 3 million.
Okay, so you suggested a commission because you thought that it would cost 3 million to do that exercise.
Okay, no, please repeat the question. I thought you were
okay.
asking.
Yeah, no, it's fine. If you listen, it will help. I'm saying in the state of capture report, you proposed that there should be a commission of inquiry, which we now know ended up being the Zondo Commission, because you could not afford the amount that was required to do that investigation, which you had estimated at 130 million rand, correct?
That's totally incorrect. very untrue.
Okay. What was the
We-
figure?
We had estimated as the power protector that we were going to need 3 million to conclude that investigation. We only
Okay,
got
good.
1.5. So the only reason we didn't finish that investigation was time, not money. We got the money late, and by the time we went full speed with the investigation, we ran out of time. There was never 130 million. I have no idea where you got that figure from.
Okay. No, that's fine, ma'am. We will deal with it. The evidence is all there, but let's say it was 3 million. The point that makes my point even bigger. I'm saying that, so I'm happy to work on your figure. So that job which you had estimated to be 3 million, you know that it ended up the actual commission cost anything between 1 billion and 2 billion, depending on who you listen to. But the point is that it was far more than the whatever you had estimated, whether it's your figure or mine, correct?
Absolutely, sir. I had a particular understanding of how soon the commission was going to take off.
Yes.
It would have been
That's my
cheaper
next.
because he would have been able to get all of the witnesses on time. And of course, the longer it takes to conduct an investigation, the colder the case becomes. And
Yes.
also, I had not expected President Zuma to expand the mandate of the Commission of Inquiry. So
Yes.
the investigation I ordered was based on certain circumstances, which is simply conclude the one that I was doing.
Yes, ma'am. That's my next issue. You also estimated that the exercise would take 6 months, and we now know that it took 4 years or whatever. And you're right. The reasons is that is what you said earlier, namely that you had to you had to balance. I mean, the chairperson went, he got about 5 or 6 extensions, I think, simply because the evidence that was before him could not just be cut at half mid-sentence, correct?
No, that's not what I said, sir.
No, I'm not. It's what I'm saying. Do you agree or not? It's not what you said. It's
no,
what
I don't agree, sir.
Okay, good. All right, that's fine.
The delay I said to you, sir, was because the mandate was expanded far beyond what had been asked. But also, at the end of the day, it's about processes such as like this, where, for example, we spent a whole half a morning dealing with things that we could have dealt with elsewhere.
Yes. No, I'm saying, ma'am, okay, maybe you're not familiar with this. Do you know that Justice Zondo, on his own estimate, when he knew the mandate, right, and how expansive or not expansive it is, then estimated that, for example, he was going to finish by the end of a particular year, and that turned out not to be the case. And then he went again, and then he went again, and then went again. He knew the mandate. So let's forget about the expansion of the mandate. I'm simply saying that because of the evidence that was accumulating before him and the need to give people a chance to refute the evidence and all that, he was, in fact, even in the end, I think he had not finished his work. But that's why there were those extensions. You don't agree with that? Is that what you're saying you're not agreeing with?
I really don't know the complexities behind the delay of that report.
All right.
Because you
But
didn't
you know
indicate to me that, sorry, sir, can I just finish that? You didn't indicate that you're going to make me an expert witness on that. I would have reacquainted myself with the report and what Justice Zondo said about the reasons for the delay.
No, ma'am.
And then
You don't have
assess
to
them
be
based on my own rationality.
Okay.
Yes.
No, you don't have to. Okay, you don't have to be an expert, ma'am. You just have to be a South African. I'm saying every South African knows that they might not know the number of times. I know it was 4 or 5 times, but they know that the committee asked for multiple extensions. That's all. You are aware of that?
Yeah, I'm just battling with where are we now? Why are we now discussing the state of capture report?
No, don't worry about where we are. I'm saying to you, okay, let me assist you. When you were going towards the end of your term, you had about 10 reports that you wanted to finalize before you leave, including CX and Friede and state of capture, correct?
I can't remember the number, but there were many. And of course, the exact names of the reports, I think there were more than 10, but we can be guided there. We shouldn't speculate. I wrote a report that indicated what was outstanding.
Yeah, okay. Just answer the question, ma'am.
I don't know what was the number, because again, if you had asked me these questions, I would have asked the public protector to assist me with that preparation. This is what makes commissions of inquiry take forever.
Okay. Yeah, especially if witnesses behave the way you're behaving. I'm asking you a simple question. I'm saying, if the reports, don't worry about the number, whether it's 9 or 7 or 8, but did the reports that you wanted to complete by the 14th of October on your departure include CX, Friede, state of capture, and I think the Mandela funeral report? There's evidence here that those were the reports that you had intended but failed to conclude at the end of your term. If you can't remember, just say you don't remember. You don't have to cast
aspersions. They are among the reports we planned to conclude as it.
I'm grateful. Thank you. I'm grateful to you. Thank you. That's all I wanted to know. Yeah. Now, I'm saying therefore that despite all those good intentions, because you couldn't just meet the deadline for the sake of meeting it, certain things had to be done. You therefore did not finalize or release those reports as you had intended, correct?
Certainly.
Good. You see how easy that is here. All right. Now, the issue that yes. Before we get to the Friede report, you mentioned we were just talking about the Nkandla report. Is it correct that in the Nkandla report you used the version of the code that was subsequently found to be inapplicable by the Constitutional Court?
In terms of reliance, this is where we spoke earlier about the difference between obiter and ratio. I definitely did not rely on it, because had I relied on it, I would have actually asked President Zuma to be punished for saying nobody built him, government did not build him a house, whereas government had built him a house. In fact, it's one of my, I didn't expect you to go there, but it occurred to me that there'll be a lot of curveballs here. I have a note here about that had I relied on the version other than the one in the booklet that Sibongile and I did, I would have not arrived at the conclusion that I did.
Okay, so you're denying, that's fine.
So I'm saying it may have been, it may have been mentioned in that version, but I did not rely on that version.
Okay.
It may have been a mistake, but in terms of what I relied on, read the report. In fact, I have, I didn't know, of course, again, that it was going to be thrown like that, but I thought that
you prepared on it, yeah. But you said you prepared on it. The point I'm making.
No, I said I did, yes, come across it.
Yes. So what's the answer? Are you denying that you used the 2007 version of the
I'm not denying that I used it. I'm saying it may have been quoted, I haven't checked it, but in terms of my reliance there, we deal with, in fact, I deal with the president's bona fides. And I say in that report that members of the executive, look there, article item in that report 2.3. I did not rely on that. You talking of members of the executive may not willfully mislead the legislature to which they
or inadvertently.
I did not rely on the inadvertently.
Okay, so
read my report. You will see the reasons. You were very happy to talk about the ratio decidendi. Read the ratio decidendi in that report.
Madam, as you might recall, maybe you don't, I was in that case, and I was one of the senior counsel who was acting in that matter. So you can be sure that I've read that report many times, and I've read the judgment, and there is reference to inadvertence in your report and in the judgment. But that's fine. That's, people can read for themselves. You and I don't have to quibble. If you don't know what you wrote, you don't know what you wrote. But
okay, sorry, I have not said I don't know what I wrote. Sir. I have said to you, I have. Oh, sorry, sir.
Just a pause, Advocate Madonsela. I was addressing Advocate Mpofu to say you now need to start wrapping up.
Okay, sure.
Your interaction. Advocate Madonsela.
Yes,
okay.
sir.
Advocate Mpofu.
Thank you, Chair. Thank you, Chair. Let me just thank you. I think I know you appreciate the kind of what I'm dealing with here. Yeah, but I think I'm going to move, for example, from this because, as I say, the report speaks for itself, the judgment speaks for itself. So there's no point in me having a debate about whether inadvertence was mentioned or not. Okay, so then let's go to Friede. I'm just going to ask you a couple of questions on this because you basically, your statement doesn't address the issues in the motion. But just since you're here, I'll ask you questions that we would like you to assist the commission with. Again, you did not have a final report or a provisional report in this matter, did you?
No, I did not, sir.
Yes, thank you. So any notion by Ms. Mazzoni or anyone else that the public protector altered a provisional report by you would be, let's avoid that word, nonsensical, would be illogical because you never had a provisional report, correct?
I would not enter that space. If a report was issued that pretended to be a provisional report from me, yes, then I wouldn't say it's illogical. I would say it's a mistake, but I don't know. I don't want to speculate about people's thinking.
Okay, ma'am. No, I understand that. You don't have to speculate. I'm asking you as a matter of logic, okay? If someone says somebody altered a letter written by me, and we can establish that I never wrote that letter, that would be illogical, just as a matter of logic. In other words,
no.
if the premise, it's what's called a premise if you studied logic here. So if the premise is false, then the deduction from that premise cannot stand. You understand? Just as a matter of simple logic. Yeah.
I think we studied logic differently. My understanding would be untrue, not necessarily illogical. I would say it's untrue.
Very good. Okay, then let's stick with untrue. Yeah. So it would then be untrue for anyone to suggest that Advocate Mkhwebane altered your provisional report if there's no such thing in existence as your provisional report. Just as a matter of logic, or simple logic, actually, not even as in philosophy, just like street logic, correct?
It would be untrue, not illogical.
Yes. All right. Okay, that's fine, whatever. But it would be logical. Is that what you're saying?
It would be logical for somebody to think that a report was issued if they saw one, or they read a judgment that said there was one. I don't want to enter into that space, Advocate Mpofu. I had said to you, I did not leave a report. You're asking me now to speculate about how to judge then anybody who
says that true statement.
I am not qualified to do that. You yourself said context is everything. For me, I think context is a factor. So I would not jump into illogic. I would look at the context.
That's fine. All right, I'm happy with that. And you, again, you had this report for what, 4 or 5 years? 2013, 2014, 2015, 2016, I think.
It was quite long, yes.
Yes. And you never finalized it, correct?
It was not finalized, yes.
Yes. And as we've now established, you never even had a provisional report.
Yes.
Right. Now,
are you going to ask me why? Because if you open a storyline, to be fair to me, I need to conclude it. These yes or no answers that want the public or the committee to fill in the gaps is improper. Maybe in adversarial justice, that's how you do. My understanding of the commission of this nature, or of a structure, not a commission, a structure of this nature, is that it's an inquisitorial process. So in an inquisitorial process, you want to know what happened, how it happened, why it happened.
Yes, ma'am. If I had my choice, we could be here the whole week and we would get into all those details. Unfortunately, I have to cover some ground in no time. Anyway, it's fine. Litigation doesn't work like that, yeah. But it's fine. So the reason why I'm asking you questions and sometimes leading questions is because the narrative is contained in my question, and you can agree or disagree with it. But fine, let's not go into the techniques of litigation. I'm saying that the report, or rather after that period of 4 years or so, there was not even a provisional report, and I think we've established that. And really all I wanted to say was that the new public protector who then came into office, obviously then because of that failure of yours to finalize it, which is not your fault because you tried, then had to take it over, and hers was not simply to just rubber stamp whatever you had done, but she was now the public protector and it was going to be her product. At least you'd agree with that.
Absolutely.
Thank you. And I'm sure that same thing happened to you when you got there, because there's always work in progress. Yeah. All right. Now, what I was really going towards, Ms. Madonsela, is that in that period of 4 years or so, you never met with the beneficiaries.
No, I didn't meet with the beneficiaries.
Yes. Okay.
It was not necessary. The most important thing that I did was to give a whole day training to the team on how to conduct a proper investigation using the standard operating protocol, which unfortunately, when I look at the final product, was still ignored.
Yes, no. And in that 4 years, you also never visited the Estina dairy farm?
No, I didn't. When the public protector is not the investigator, you don't do all on-site visits.
Oh, thank you.
It's
Good.
just
because sorry, ma'am.
You trust your investigators. I had Advocate Celia doing that. And when Advocate Celia was struggling with it because she had been doing early resolution for the longest time, I assigned Mr. Samuel to do that. Of all of the investigations that I have done, I didn't visit every corner of the country to see everything. It was impossible.
Yes, no, I'm just establishing the facts. I'm not.
Okay, I'm giving you context.
Yeah, that's fine. The reason, let me give you context. The reason is that one of the criticisms leveled against Advocate Mkhwebane, who dealt with this matter in 7 months and finalized it, by the way, just as an aside. The reason why, one of the reasons she's criticized is because she did not meet with the beneficiaries. I'm simply saying that in 4 years, let alone 7 months, you did not meet with the beneficiaries. You've explained why. I just wanted as a factual fact that you did not meet with them. That's fine. So
sorry, sir, you made an aside. She did conclude it in 7 months without a forensic, and it was sent back by a court of law.
Yes, well, she finished it in 7 months and it was sent back by a court of law. That's a
balancing rigor with speed. Excellence is about both.
So excellence is sitting on it for 4 years. You regard that as excellence, and not even producing a provisional report?
Advocating both.
Are you being serious?
If you're sitting here to try and compare me with the public protector, I'm going to ask this committee. Now, wait a minute. I'm going to ask this committee to go and check at the public protector office if there isn't any case right now that is as old as these cases that you're trying to make me look bad for.
11 years. You won't find a case that is 11 years or 7 years or 6 years or.
Okay, let's do that.
Yeah, no, Mr. Niels van der Merwe already assisted us in that. I'm not saying you're the one, madam, who says that because something was reviewed, therefore it means it was not of quality, which is a ridiculous statement to make. Yeah, but the point I'm making is that I'm simply saying to you, it is better to produce a report, and if it is reviewed by a court, that's good. That's good too, because that's a learning opportunity. Than to sit.
Can I respond to that, sir?
Yeah, that's
all I was saying. Can I respond
to
that? In my training, which I trained I've trained even under Advocate Mkhwebane at the center that I helped establish in Durban. I have said, no, rather than do a shoddy job, do not conclude, because the worst thing that you do, and this is the training that you get in every training as a public protector, is that when you say there was no wrongdoing, you are throwing your whistleblowers under the bus. When you say there was maladministration, when there was corruption, those who have committed corruption rejoice. That's a universal understanding. So yes, it's better not to conclude an investigation than to sign off on an injustice. That's my approach. What Advocate Mkhwebane, your client's approach is, that's her approach. But I'm just putting on the stand my approach. And that's the training I give to people, is do not sign off on a shoddy job, because there's a lot of people that will suffer, including the complainants.
Yes. Well, I hope by that you're not suggesting that the report, simply because it was reviewed, it was a shoddy job. But if you are, that would even be more ridiculous than what I was commenting on earlier, because you know that there were many reports of yours that were successfully reviewed, or in your language, they were shoddy jobs, including the SABS judgment, correct?
There's no judgment that has been issued that has suggested that I did not understand the Constitution, that personally held me accountable, even with personal orders. There's no judgment that even suggested that I was dishonest. This was one of my responses to your letter when you were trying to surreptitiously throw this into this.
No, ma'am. I'm saying now you're talking about completely different things. You see, that's the problem with you. You said, I put a proposition to you that you did not do a report in 4 years that the public protector finalized in 7 months. Your response was that, well, that report was reviewed successfully. So let's keep it there. So I'm saying that the fact that a report is reviewed successfully is something that happened to you many times, including the judgments and National Empowerment Fund versus Public Protector. That is a 2017 judgment. SABS versus the Public Protector, where the following was said at paragraph 2.8, oh yeah, you can please, it's bundle C, page 1460. I'm wrapping up, Chair. Item 41.
Please let me respond when you're done.
Yeah, like I've done all day. Believe me, we're not going to move to the next question before you respond. So I think you would have noticed that's what has been happening all day. Yes, which one is that? SABS. Yes, can you go to paragraph 2.8? Okay. Sorry, Ms. Madonsela. It says there that, so I'm just trying to find the paragraph. It says the public protector exercises discretion to entertain these complaints despite the expiry of 11 years from which the second complaint was lodged, and despite Section 6(9) of the Public Protector Act of 1994. You remember that? That was another one where you had, according to this judgment, at least breached the 2-year rule and went over something that was 11 years old.
Right. Do you want me to respond to that, Sam?
Yes.
Number one, I did not involve myself in that litigation. Number two, the 2-year rule is not a rule of a prescription rule. It's a discretionary rule. Number
Yes.
three, which I asked you in all of the, in the wild accusation that some of my reports have had negative comments from judges. I said, I'm not aware of a single one of my reports that was litigated up to the Constitutional Court, not even up to the SCA. The very first case that I litigated as public protector was Advocate Mushwana's case. That's the male and guardian case. The NEF case, I disagree with the judgments. In fact, I have included in my teaching on administrative law every year ever since. It's the subject of my, if you read online, my inaugural lecture, my social justice lecture, I talk about how that acting judge erased the complainant. You know what, the things that you said last week about how your client was being ignored, the inconvenience to her was not mattering. That's exactly what happened in the NEF case. And the judge even comes to a conclusion where he says she knew that she did not qualify. When that evidence was never adduced, it's not even in the judgment itself. So that judgment is pathetically wrong. If I had been public protector, I would have litigated the NEF judgment right up to the Constitutional Court. Because if there's a judgment that is so far removed from proper administrative justice and Ubuntu, it is the NEF case.
Yes, no, I accept that you disagree strongly and you have strong words to say about the judgment. That's fine, join the club. I'm saying that so you agree therefore that the fact that a judgment makes such scathing remarks about you does not necessarily mean that they are correct. It could be shocking or all these things that you've just said.
I think if it's the Constitutional Court, we can't escape the issue of shoddiness. I
see. So the Constitutional Court, unlike the lower courts, is incapable of getting it wrong. Is that what you're saying?
He is the ultimate guardian of the Constitution.
Yes. No, I understand that, ma'am. I'm saying, therefore, if this finding in the NEF case was made by the Constitutional Court, you would no longer think that it is shocking and all the things that you've said.
I would be sad, but I would understand that that's the law now. The complainant doesn't matter. All that matters is inconvenience to an institution. If an institution strings you along, it's okay. And if a constitution fails to do triaging, which is a basic in every institution, whether you're doing UIF, whether you're doing the social grants, or you're going to hospitals, triaging to determine whether you are at the right place or not is a standard requirement. And a judgment that says it's irrational to have required the NEF to do triaging is incorrect.
Yes.
It's totally incorrect. But if
No,
it had been done
fine.
by the Constitutional Court, yes, I would have been said, but I would then understand that's the new law of the land.
No, absolutely. That's a different question. It would be the final, in other words, there would be no other court
Yes.
to go further, but it would still be as incorrect as it was when it was made by a lower court, correct?
Absolutely, if it's approved. And none of my decisions have been taken even as far as the Supreme Court of Appeal.
Good. No, we're together there. So it would be wrong. And that in the SABS case, I'm just trying to save time. It says that the public protector joined the second, paragraph 14, sorry, ma'am. That's 1477, Sepo. Public protector joined the second complainant with the first complainant because of the view that the withdrawal of the permit was directly connected and in revenge to Praduba's allegation against SABS. Despite not being able to decide the first complaint, the public protector persisted in entertaining the second complaint. Upon a reading of the papers, this acceptance of Praduba's view was not done with an inquiring mind as required by the public of the public protector. So in this other judgment, Judge Potterell said that you had approached the matter without the inquiring mind required of a public protector. Was that one also outrageous and all the epithets?
Well, no, I don't think it's outrageous. I think that's Judge Potterell's opinion. And of course, I would have still taken it on appeal. And that's the case that we dealt with extensively as a team at the Public Protector, and think tanked that whole entire brains trust. We think tanked a lot of times, and I do disagree with the judge respectfully, but I'm not saying it's one of those judgments that horrify me. The NEF judgment horrified me to the core. As a result, I've been using it in my teaching since then.
Yes, but I'm saying that on the SABS case, the final word is that you approached it without the open mind. In other words, in a biased fashion. You accept that?
I did not do so. If I had been involved in the litigation, of course, I would have defended myself. When Advocate Mushwana was no longer Public Protector and I had to deal with the mail and guardian judgment, I asked him what his thoughts were on it. Okay. But that said, all I am saying is I disagree with this judge, and I'm saying there is no judgment by the SCA or the Constitutional Court that suggests that I do not know what I'm doing.
Well, okay, ma'am. Would you agree that if you are biased, as this judge was saying you were, in the approach to the matter and not approached it with an open mind, that is a serious accusation against a public protector or a judge or somebody entrusted with so much power? Bias. If this judge says you are biased.
It certainly would have been, and I suspect that given the kinds of monitoring that I was subjected to during my time as Public Protector, this matter would probably have been brought to a committee like this. Unfortunately, the decision that you're talking about was made when I was no longer Public Protector.
Yeah, no, ma'am. I think I accept all that. I'm saying there's a judgment, which is the final word. You've said that correctly. That is the opinion of Judge Potterell. That's not what I'm disagreeing with. In fact, I agree with that. There's a view out there with those who don't know that would differ with you that the judgment is the opinion of Judge Potterill, but I'm not one of those because you and I at least are educated in law. That's not the point I'm making. The point I'm making is that this is a judgment. It is what it is. It's a judgment of the court, and it is a final judgment. And it says that you were biased in your approach. And I'm saying that that is the legacy of your dealing with this matter. Let me I'll read you another part, paragraph 9. The public protector dismissed the complaint of the SABS that after 11 years, the file and documents pertaining to this matter were destroyed, and therefore she should not consider the complaint. In fact, she took umbrage with the SABS for doing this loss of records. This is an astonishing stance. If the SABC knew there was a complaint 11 years earlier, they could have safeguarded the documents, but the public protector simply did not inform the SABS of the complaint. She ignored the fact that the relevant person who withdrew the payment was available for an interview in lieu of the destroyed documents. What makes matters worse is the public protector herself submitted that her office unfortunately misplaced the original complaints and correspondence submitted to Pradubas. The pot calling the kettle black. The public protector balanced the mismanagement of the documents of the SABS with the prejudice Pradubas would suffer. Herein lies the substantive irrationality and the decision of the public protector as set out below. This is what I call scathing remarks against not only your bias, but also allegations that you ignored evidence, which is even worse than bias. You engaged in what the judge called the kettle, calling the pot calling the kettle black, the pot being you in that example.
Well, again, with due respect, I disagree with the judgment. Yes. But again, I don't know where this is going. I do realize that I am being impeached long after office. Unlike Advocate Mkhwebane, for whom this was supposed to be about, she has been given in advance what the allegations are, as opposed to what's happening here. I need now to go and look at the case that you're putting forth. I need to look at the investigation file and look at who was I working with as an investigator and to see what really happened, because I wasn't involved even in the litigation. In fact, even with the NEF case, I only discovered that it had been reviewed successfully when I was talking to people about the potency of the public protector to give remedies that are unusual. So I'm going to say I disagree with the judge's finding, but I would say that the finding of a judge of the High Court that is not upheld by the finding of the Supreme Court of Appeal or the Constitutional Court does not have the same weight in terms of who you are and what you can offer than the finding of the SCA and the finding of a Constitutional Court.
I see. So you
that's my opinion.
Yes, that it is your opinion and it's wrong. Yeah. But the finding of a court of law, which is final, is a finding of a court of law. It's correct that it's an opinion of that court, but it is if there's another case that comes up in Gauteng, this judgment would be binding on the judge, unless, as you know, unless if they find that it was clearly wrong. But the point is that there's no such thing. The binding effect of a judgment is the same, whether it's a magistrate court or a high court or a SCA or whatever. If it's a final judgment because it has not been disturbed. But that's fine. You can deal with that maybe when you're dealing with your students. the point of the matter, the only point I'm making to you is that you are the one who started making the snide remark that if a report is, you'd rather not finish a report than have it reviewed. I'm showing you that not in these cases, you finished the report, quote unquote, but it was reviewed. So you had the worst of both worlds. Because the churches found it as biased and astounding and astonishing, and the pot you calling the kettle the other, that would be the respondent, black.
May I just correct you there, say?
Yes, ma'am.
You are not telling the truth when you said, I said I would never finish a report rather than have it reviewed. I said that I would not finish a report if the investigation has not been thorough. And I said that if I have to choose between promptitude and rigor, I choose rigor, and that's what I teach my students, and that's what I teach practitioners, and that's what is in many of these documents. So I do disagree with you when you are saying there's no different in waiting to a judgment of a high court and the judgment of the Supreme Court of Appeal and the full bench of the Constitutional Court. I disagree with you, say. But again, lastly, to say, you've put me on the stand as a counter being impeached person. Because I don't know really why you brought me here. You brought me to answer for cases that I dealt with. You should have told me so, that this is about me, in which case then I would have spent days at the Public Protector team to get all of the information, because context matters. Earlier on, you accused me of not prioritizing Gogo Dlaminis. These are two Gogo Dlamini cases. The NAF case is a case of a Black woman of foreign origin who was promised money wrongly because he wasn't Black under the Black Empowerment Act.
Okay.
And after toing and froing, after the NEF going to the extent of establishing a bank account with her, and therefore her having a legitimate expectation that the
We've
NEF
got the judgment.
pay the money.
We've got the judgment, ma'am.
No, but I know, Advocate Mbof, you can't have your cake and eat it. You can't.
No,
if you want to
I'm
bring
not...
these matters here, they have to be contextualized.
Yeah, but we don't have time, ma'am. You know,
but then don't bring them here.
The judgment is in front of the committee. I'm sorry, madam. I'm simply saying this judgment is in front of the committee, so don't worry about going chapter and verse. It was already submitted last year. So we
you've
know
spoken over me again, and it's okay when you do it, because I'm giving everyone the context.
Chair, please,
you're the one who said context matters, so it matters when you want it to matter.
Okay, ma'am.
It doesn't matter when I want it to matter.
I'm sure the chair will give me extra time. Go on and be my guest.
Thank you, Advocate Madonsela.
Thank you.
We're about to wrap up now.
Yes, Chair. I was really, but yeah, really. Now, madam, all I'm saying is that in this case of SABS, your report lacked in both rigor and promptitude. That's the point I'm making. You said you balance rigor and promptitude.
Yeah.
Because it was said that there was an 11-year period, and yet the report was found to be not only shoddy, but biased by the judge. Would you agree with that? Rightly or wrongly?
Firstly, I was public protector for 7 years. So if the case took 11 years, that would explain why some things somehow could not be found towards the end.
Yes.
I just think the first thing in this case is to find out from the public protector files what really happened. But I disagree with you, say, with due respect.
Okay, good. No, you don't disagree. You disagree with the judge that says it was a shoddy job. I'm saying it was like Mr. Nyatela's case where the 11 years included the entire 7 years of your term. So I don't think that's an example of someone who balances rigor with promptitude, because this was worse than shoddy. It was biased, and it also took an extraordinary amount of time, and as Judge Potterill called it at paragraph 19, quite astounding. And she said this is the remedial action that you made was nondescript. She says the vague and nondescript and unobtainable remedy ordered was provide the complainant with a remedy, including a reasonable amount as a settlement for consolatory compensation to address the distress and trauma experienced by him and his family as a result of the manner in which matter has been concluded. Says leaves one dumbfounded and needs no further address, said the court. That is shoddy.
If I may help you, Advocate Mpofu, in ombudsman decisions, it's not unusual to ask for two things: to ask for an apology and to ask for the wrong party to give some kind of compensation that is determined by them. You remember the case, the Sowetan case, where a young lady had been raped and her matter was postponed for over 8 years, and then we did an own investigation on it. What we did, we asked all of those who were involved in the conveyor belt to, number one, an apology from the Minister of Justice, and two, what we called sorry money, which of course the NEF judgment says there's no such a thing. We said some kind of sorry money determined by the Department of Justice, with the Department of Justice did come up with that sort of money. In fact, the report was accepted even before we finalized it. That's why we called it, no, it's not, they called it justice. And then what Dawkins says in hard cases, taking rights seriously, is in these very hard cases, when you can't find hard law, either in common law, the Constitution, or statutory law, you have to look at public policy. And one way of ascertaining public policy is what has been accepted by government before. It was on that basis that I decided these cases.
Yes.
Thank you.
No, yes, thank you very much. I understand. And public policy includes the mandate of the Reserve Bank. I'm still, ma'am, maybe you're getting me wrong. I'm on your side here. I agree with you. In fact, I've read that report in the SABS case, and I think that it's not that bad. Could have been much better. There's room for improvement, but that's not the point. The point is that the judge, and there are people who think that once a judge has spoken, then we should not inquire. The judge says it left her dumbfounded as to how you could give that kind of, it didn't leave me dumbfounded, but the judge said it left her dumbfounded, and it was quite astounding. And she says she doesn't even know what was going through your head when you made such findings. That's the issue.
Well, Advocate Mpofu, do you remember the SABC case, what the judge said in the High Court? And because I was public protector at the time, I litigated it and took it right up to the SCA, if I'm not mistaken. And eventually I prevailed. So I do think that I give respect to High Court judges, but that's why we have an appeal system. I give more weight to decisions of the SCA and the Constitutional Court.
Yes. Okay, well, for the sake of time,
10 minutes remaining. And then
I'm wrapping up now. Yes. Thank you, Chair. But Chair, can you make it 15? I promise I won't go 1 minute over that.
You will do it in 10 minutes.
Okay.
I
All
trust.
right. Ma'am, I think you're getting me wrong again. I'm saying that my point is not the point you're making. My point is that churches can get it wrong, and that the mere fact that the church said this is outstanding, astounding, and she was dumbfounded by your conclusion, does not mean that that is so. If someone had to inquire into that, then they would have to look into the report and themselves be dumbfounded. You agree?
I agree. They would have to look at the facts. They would have to look at your understanding of the law,
Absolutely.
just logically, and see whether it was reasonable for the judge to make that conclusion.
Thank you very much. That's I am. Thank you. That's a hallelujah moment. Thank you very much. That's what we've been trying to explain that ad nauseum here. Yeah. All right. Now, thank you for that. Now, in fact, if it was a court, I would just stop there, because that's the $1 million answer that you've given. But seeing that we're here, let's just wrap up. This chairperson, is going to ensure that did you ever say to me, or rather, why did you reject the Fred report more than once?
There were various reasons. I think in the earliest drafts, for example, there was a version that said somebody said the Premier said this. And then the question was, why then was the Premier not interviewed? And then because in the public domain, as you said yourself, that the powers of the public protector include looking in all spaces. In the public domain, there were already allegations of corruption involving the Gupta family and others. So it was important to then, in terms of our standard operating protocol, to look into those relationships and how those relationships played out. And also in Mr. Makashule at some stage dropped at my office for a cup of tea. It wasn't included in the report because he just said he was visiting me, but he indicated that the person at the center of this was Minister MEC Zwane. That's why I had said to Mr. Samuel that all of these things should be considered. The important thing was when you do an investigation, everyone who was involved in the conveyor belt must be held accountable. And then the report at the end of the day has to cover all of that. So the early one had indicated that the Premier had some role in it. And then the next one had excluded now all of the names. And then the next one had the names, but had not done the in-depth forensic.
Yes. Okay. No, let me just try and summarize it because we don't have time. So you were not happy because they had not interviewed some of the role players, correct?
Yes.
Right.
And they had not decided the accountability. I think the key was not so much the interview, it was both the interviews and the accountabilities of those role players who had already been mentioned in the investigation.
Right.
And the Mail and Guardian again is whatever you hear in the evidence seeking process, you must follow it through until get to the bottom of it.
Yes, and the public protector, that's Advocate Mkwebane, then did that, and actually, unlike you, went to see Premier Magashule. According to Mr. Samuels, she insisted that they go there. She went there, and then she invited him, as she should in terms of the law, to respond in terms of section 7.9. You're familiar with that section, which was to give him an opportunity and the MEC to respond. You would agree with that? That's how it should have been done. That's what you were asking for, actually, correct?
Well, by the time I left already, we were considering section 7.9 notices on those people. And you will see that in the evidence of Mr. Samuel.
Yes, I know you were considering, but
they were being prepared, so it wasn't a new thing. Yes.
Yeah. No. That's it. That's a difference between a considerer and a doer. I'm saying that Advocate Mkhwebane actually went physically herself with her body to the office of the Premier, which is what you did not do, and she sent, not considered, the section 7.9 notice. I'm saying that's the kind of thing that you wanted to be done, so that these people who were mentioned should be confronted with adverse findings and be asked to comment, which is what section 7.9 is all about, correct?
I don't think what is at issue, I think we keep running into spaces. I think what is at issue here is how those names then disappeared from the report, if you're saying that was what was decided.
No, but you see, that's the problem with you. You make these judgmental statements. Do you agree that section 7.9 is an opportunity for aude alteram partem? In other words, if you have a finding against me, and you give me an opportunity to explain it away. That's what the purpose of section 7.9 is, correct?
It's an extension. There's various stages of aude. Yes, I agree. But in the first aude is the letter that is written to you to tell you that there are allegations against you. Meetings are also part of the aude. And yes, section 7.9 is one of the instruments for exercising or for extending the aude to implicated persons.
And therefore, if in the exercise of my aude alteram partem rights, I then respond to your section 7.9, and I respond in such a way that is satisfactory to rebut the adverse findings, then those findings do not disappear. They must go, because I would have answered. That's the whole purpose of section 7.9. It's not just to go through the motions. It's to give somebody an opportunity to explain what might be a provisional adverse finding. So why do you say that the findings disappeared? What do you mean by that? Because they were not there simply because there was an answer in a detailed section 7.9 response.
Well, again, we are talking about two different approaches. I will speak to my approach. In my approach, I would indicate all of the evidence presented against a person, and then I will indicate what they said. And then you and I would not be sitting here speculating about what was the original allegations that seemed to be worth considering as implicating someone, and how they responded to them and how you resolved it. Again, it's in the manual that I left, and the processes that investigators are supposed to follow.
Yes, but that's exactly what happened, madam. The report details the allegations against the Premier and the MEC. The report refers to the letters that were written to them. I think one of them was the 7th of July, 2018, if I'm not mistaken. And the report deals with their responses. So I think it might be a good idea for you to withdraw the snide remark that the findings disappeared, because it's exactly what the law requires, that when somebody gives you a satisfactory answer, you should you cannot continue to make adverse findings against them. In fact, that was one of the criticisms that was made against Advocate Mkhwebane in the rogue unit matter. So if the Section 7.9 response is satisfactory, then those findings must go. So would you withdraw that snide remark that they
I will not advocate Mkhwebane, I will advocate Mpofu. I am going to revisit the report and revisit the information.
And we'll send you the Section 7.9. I'll send you the Section 7.9 letters. And once you have confirmed that what I've just told you is what happened and what is in the Section 7.9, will you withdraw that snide remark?
If it's proper to do so, I will do so. But you must understand that we no longer, or at least during my term as Park Protector, we no longer concluded purely based on what the response was from the other side. We evaluated all of the evidence together.
Yes, that's exactly what happened. That's the point. So if we can show that the evidence was evaluated and it was covered in the Section 7.9, then you will withdraw that snide remark, correct?
Well, if you call it snide, I will withdraw it if there's a need to withdraw it.
Yes.
At this stage, I do not see the need to withdraw it.
That's
I just said the findings did disappear. I mean, the names did disappear, and the names did disappear.
No, by that you mean the Premier and the MEC,
yes.
They are referred to. So that's a second snide remark, which is incorrect. The Premier and the MEC are referred to in the report. I'm telling you as a matter of fact. So that's also a false and unnecessary accusation. But it's fine. We'll cover it in a letter which we'll send to you for you to withdraw the snide remarks.
No, please, let's keep it everything in this meeting. I don't have an attorney advocate, Mpofu. I cannot keep responding to your litany of letters.
Okay, no, it's fine. Well, you'll deal with it as you wish.
Let's keep it on this platform. It has been aired on this platform. Let's deal with it on this platform. No, that's fine. I'm just telling you that we will send you a document that requires you to withdraw those snide remarks because you are making them in public and they are uncalled for, vindictive, and based on completely baseless. And if I may borrow from Judge Potterell, astounding, and I am dumbfounded. And she was right that the pot is calling the kettle black. That's the sum total of your evidence. Thank you, ma'am. Thank you, Chair. Well, it's so good that I haven't called anybody anything. If we're talking about outstanding, insulting, no, I'm just quoting the judgment. If you I'm just quoting the judgment.
No, thank you, Advocate Mpofu. Please switch off, Advocate Mpofu. Thank you. Okay, no, Chair. Thank you. Yes, ma'am. Sorry, the chair will give you an opportunity. Before I switch off, I just want to say I was just quoting the judgment. Thank you, Chairperson. Thank you, Advocate Madonsela. Over to you.
If we're talking about things to be withdrawn, you have maligned me. That's okay. I could see those snide remarks from the very first letter that I received from you, from the attorneys. That's fine. But I would like you to withdraw all the insults and snide remarks that you've made against the Commissioner of Oath who did the first document. And for the purposes of this committee, I have indicated that the status of an investigation, the status of an affidavit was dealt with in a case here in this province. If we're talking about third decisis, it was in this province, and the case is Minister of Safety and Security versus Mustafa Mohammed. And that case says that the fact that an affidavit is not initialized on every page does not invalidate it. And to pass words such as illegality, criminality, that was low. Thank you.
Chairperson, if you allow me just to, well, firstly, ma'am, yes, I was not talking about invalidating. I was talking about the criminal actions of signing an affidavit after it has been attested, but that's a separate thing. But on the second point, if I have made any snide remarks to the attorney, unlike you, I definitely will withdraw them. We're certainly going to pursue, that matter with the attorney. We'll ask for an affidavit. If it turns out that indeed he was not in, what's the place, Randburg, or forgot the name of the place now, in Johannesburg, but he was in Stellenbosch, then that will be clarified in his affidavit, or when he supplies us with an itinerary or a plane ticket to that effect. It has happened before. But if all that turns out to be kosher, I will certainly have no problems with withdrawing as a professional person. But your postponed withdrawal will be dealt with in due course. Thank you, Chairperson.
Thank you.
Thank you, Advocate Mpofu. Thank you, Advocate Madonsela. Honorable Sukas, I just want to get to the next stage.
Yes, Chair. Yes, Chair. My hand is up because actually both advocates has now raised the issue that I actually wanted to request. The issue of whether an affidavit must be signed or initiated by the Commission of Oaths has not been settled, I think, for us as the committee. I have looked at both the Act and the regulations. And in my layperson's view, it is not the case. But as a member of the committee, we cannot judge a matter unless the law is made clear to us. So I would request, Chair, that the evidence leaders address this point, or failing which that the legal staff put it before the committee. Thank you.
Thank you, Honorable Sukas. This is going to be an adjournment. We're not done yet. The time now is 6 o'clock. We'll adjourn our meeting and start tomorrow at 9. It's a shorter day. And when we start tomorrow, we'll start with Advocate Mayosi. We'll interact with the witness, followed by the members. So at that point, I want to say thank you for, we have stretched the day up to 6.
Thank you, sir.
Whatever time you would have given before, you've taken it back and even more to get them both. Honorable Maneli.
No, thanks, Chair. Just on the point raised by Honorable Sukas, I'm not sure whether you are saying then, Chair, you are ruling that because we are adjourning, it's a matter that may need to be clarified in the morning on the standing of this affidavit, because we've now gone through point by point as we listened to Advocate Mpofu interacting with it. I think it's important because in the records of the committee that we can place it on record in the morning, whether there's clarity now on this matter or not, right? So I'm just saying she made that point and I thought you were coming to just clarify it, but if not clarified, I think we'll still need it on record, because there was an opposing view that said it's not an issue and we should proceed in that score. Thank you.
Thank you. Advocate Mpofu.
Thank you, Chair. Sorry, it's just to be helpful. Chair, if the issues of law and legality and what have you will be argued at the end, but if you want to, which seems to be what is being suggested now, if that legal argument is going to be brought forward, then it should not be confined to that point. I've made about 4 or 5 serious criticisms, including from about 20 past 10 to when we broke for tea, on the so-called affidavit, which I call a statement. So all those points then, if we're going to now get into legal argument, both sides will have to address them. And if I don't know why they must be addressed now, because all the legal points, including the binding nature of judgments and whatever, have been left towards the end, correctly so. But if we're going to have a stop-start legal argument, then it's fine. Let's do it, but let's not just do it on one point. Let's do it on all the issues that have been raised, because the status of that document as an affidavit or not is dependent on all the 4 or 5 criticisms that are available. Thank you, Chair.
Thank you, Advocate Mpofu. Honorable Maneli, I thought I'd responded when I said we're not concluding today. We're adjourning to start tomorrow at 9. If there are any other issues, we'll deal with the issues tomorrow, even before we conclude. Thank you. On that note, honorable members and everybody else, colleagues, Advocate Madonsela, we will adjourn the meeting and meet tomorrow at 9. Thank you very much.